morning.
At this time, we'll now call to the order the Criminal Justice and Public Safety Committee. Representative Marston, do you wish to lead us in the Pledge of Allegiance? At this time, we will now open the public hearing on House Bill 1067. At this time, we recognize Representative Abramson.
Thank you, Mr. Chair, members of the committee. I'm Representative Max Abramson, representing Hampton, Hampton Falls, and Seabrook. Reintroducing for the third time what's now House Bill 1067 FN. And by the way, I want to thank you all for voting to pass this unanimously twice before. The first time it was sent off to the Senate, and like all the other legislation we sent their way, they were all the bills were tabled and killed because of the coronavirus lockdown. And the last time it was sent through, it was vetoed. And I did read the veto message. However, there was a reference to someone somewhere, either in the Department of Justice or in one of the 10 county attorneys' offices, who had an objection of some kind, and they whoever that mystery person is has never contacted me, so I'm not even going to try and speculate. I do want to mention, though, that there is a drafting error in the bill versus what I requested from Legislative Services. I asked that this bill be limited to just Class A felonies. There was an issue with Class B felonies where I wanted to pass this bill last year and then come back and ask the committee to work on other Class B felony related issues. And of course that didn't happen because of the veto. So if you look down, the only operative wording in the bill is on page 1 at the bottom, Part G, notwithstanding subparagraphs A and B, for any offense under RSA 631, Section 1, within 6 years of the victim's 18th birthday. And then Legislative Services, for some reason, decided to add in this additional language from last year's bill, which isn't supposed to be there, which is for Class B felonies under RSA 631, Section 2. So again, this is something I have to come back with another amendment on, but I needed to hear from whoever the mystery person was what their objection was to the language. I'm told that there's some other alternative language posted on the internet somewhere, but again, no one has contacted me by email, by text message, by phone call. I've tried contacting the governor's office and have not heard back from them in 3 years. So that's kind of a mystery, and I feel like what they're doing is handing this back to this committee to have this committee rewrite the bill. And if you want to take that approach, of course, it is By rules of the House, it is now property of the Criminal Justice Committee. It's no longer my bill, but I am willing to do the legwork to rewrite the bill through a committee amendment. So the reason or the rationale for the bill is sometimes people commit felony assault against a child. We have a statute of limitations for felony assault, which is 6 years, which makes sense for adults. I absolutely believe in the need for the statute of limitations. The New Hampshire Supreme Court argues that why we need to have a statute of limitations is to get the prosecutor moving, not to just sit on cases, and to assure that if you're accused of a crime, that you have a reasonable amount of time to go back and get witnesses in your favor. The reason that we maintain a statute of limitations for most types of crime other than murder is that witnesses for the defense will forget, or they'll move, they'll become inaccessible. You won't be able to do an out-of-state subpoena and bring them in to testify in your favor. So the courts want the process to kind of move, not have cases just sort of bogged down. The problem with felony assault against a child is sometimes these cases of abuse start when the child is 4, 5, or 6 years old. So if the victim is 6 years old, then by the time they're 12 years old, the statute of limitations has already run out. And what we've done with felony sexual assault against a child is we don't start the clock, we don't start the stopwatch until the victim turns 18. So I felt that we should be using the same type of logic that yes, there's still a statute of limitations under this bill, but that clock shouldn't start until the victim turns 18, when they're out on their own and they're not potentially either financially dependent on the abuser, or the abuser might still be in a position of authority over them until they're 18 years old. Once someone's 18, then it makes sense that the clock should run. So that's the rationale for the bill. It's passed unanimously through the House and Senate multiple times, and hopefully whatever rewording needs to be done, we can get that done before executive session.
Representative Abertson, thank you for your testimony. I will, if you bear with us for about two minutes, you may be able to see the language that you were referencing that you haven't seen yet.
Okay. Yeah, I'll be around this morning.
The over-under time frame would be about 2 minutes, I would say. So just
Okay.
bear with us.
I'll hang around. I won't go anywhere. Oh, did anyone have questions?
I was encouraging, just stay where you're at. It should be very shortly.
Oh, I assumed that somebody else was going to be speaking also on the bill.
If you wish to be excused, you may be excused.
I can wait.
Just to clarify to the members of the committee, there was a letter that was signed by each county attorney, and it was actually drafted by the Attorney General's office. That, reading the letter, I believe it discussed the intent of the bill, which was formerly HB 239. And what it did was provide, in that letter, suggested language that would accomplish the same goal without the fear of potential unintended consequences. So the suggested language was in that letter. The amendment is word for word that suggested language. So it wouldn't, and I just thought the prime sponsor, and I apologize for not sending it to you in advance, should have an opportunity to look at, or at least review that while he's here to testify. Representative Amerson, you can have this copy. And please watch out for those wires.
Does kind of look like almost the exact same wording. Do you mind if I run this down to legislative services and take out the Class B felony part, so we're just limited to the Class A felony like the original?
You're free to have them make a separate amendment if you prefer. That's the right of any member of the body.
Okay, and I'll make sure that it follows the
I would suggest that this language was specifically I don't want to take credit for the wonderful drafting of it. It's literally word for word what was suggested by in a correspondence from each county attorney in New Hampshire and the Attorney General. But the member's free to proceed as they wish.
All right, and I'll be downstairs and I'll return with the.
Thank you. The member is excused. At this time, we'll now close the public hearing on House Bill 1067. At this time, we will now open the executive session on House Bill 1067. Representative Roy, you wish to be recognized to make a motion.
I wish to move OTP as amended
And offer an amendment?
and offer amendment number 2022-0168H.
Does a member wish to second that motion? That has been seconded by Representative Bourdonnais. Representative Roy, you wish to speak to your motion?
I do. The sponsor's intentions notwithstanding, we won't be able to do much better getting a language that will pass muster than language given to us by all the county attorneys and the Attorney General. This is probably the most vetted language we've seen yet, so I think we should just go with it and move it on.
That was well said, Representative Roy. Representative Rhodes?
Thank you, Mr. Chairman. I basically echo everything that Representative Roy has said, and the concern with not being able to sign this legislation that obviously people were in favor for was because it was actually going to hinder if an assault had taken place, after a certain age. We certainly don't want want to limit anybody because of their age to be able to have their justice served. So I definitely support the amendment as written.
Representative Newman?
Does the amendment that's going to be drafted also take out the part that the representative was concerned about Class B felonies? Would that then be gone so it wouldn't be a problem?
The amendment that's been offered was the one that was recommended by, I shouldn't say recommended, it was suggested language that, what the letter was really saying was they understood the intent of the bill. However, as passed by both bodies, there was some concern of some unintended consequences. And it was suggesting if this is the goal of what is wished to be accomplished, this is the suggested language to be used. I thought this is word for word going to match what was suggested in that language. I'm not saying that the Attorney Generals are recommending the legislation, but I would also be very cautious with changing the language, considering that this was HB 239 passed on unanimously out of this committee last term and last year, and it got all the way to the finish line. And out of abundance of caution, that's why I didn't make it. So we're addressing that issue of that the potential unintended consequences are addressed by this. So I wouldn't support any deviation from that language.
I support everything you said. I will support the amendment. My question was about the process. I thought I heard in the testimony that the representatives mentioned something about Class B felonies that he was going to take out, and whatever he was going to do with that. And I'm just wondering if the amendment as written now takes that out or does not take that out. Does it replace it so it's all gone or not? It's just that's my question.
I don't believe it's appropriate for me to tell another member to not go ask for an amendment. That's not fair to anyone. So I don't believe it takes, what's here doesn't take it out. I believe the witness may have wanted to do that, but I wouldn't support doing that.
Thank you. I just wanted to know whether it did or it didn't. I didn't have a feeling either way. I was just questioning what the amendment replaced and what it did not replace. Thank you very much for the explanation.
Representative Rung, you're
Yes.
recognized.
Thank you, Mr. Chairman. I'm just subbing today, but I'm a little curious why we're moving this now until Representative Abramson comes back, because I think his expectation was that we weren't going to vote on an amendment until he had the opportunity to offer another one. I was just wondering if we could just delay this and give him the courtesy of presenting what he has.
In order for an amendment to be presented to the committee, it would have to be either a member or be a substitute on the committee. And as the chair, I exercise my discretion. I would not recognize someone to offer an amendment that wasn't identical to the language offered, recommended by the 10 county attorneys and the Attorney General's office. Because I believe that this is a bill that we've discussed extensively for now multiple terms, and I'm not sure anyone opposes the intention of the bill. So I think it's really the precise language that we really want to focus on.
Yeah, a follow-up? No, I understand. My concern was just really a professional courtesy, so that when he comes in, he's not blindsided that we've already voted on another amendment.
I understand what the point that you were making.
Okay.
Thank you.
Yep.
At this time, the matter will now be put to question. If you're in support of adopting amendment number 0168 H, please say yea. If you're opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch. Yes. Representative Burt. Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman. Yes. Representative Lang. Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. Representative Schultz.
Yes.
Representative O'Hearn.
Is there a substitute for Representative?
I haven't, no, no. She's subbing for Laura Panalakis. Correct, I have, okay, oh, wrong, all right, very good. Okay. So it's Representative Rung? Thank you. Representative Bourdonnais?
Yes.
Representative Perez?
Yes.
Representative Newman?
Yes.
Representative Bolden?
No.
Representative Conley?
Yes.
Representative Klein Knight? Representative Bradley? Chairman Abbas?
The chair votes yes.
17 yeas, 1 nay.
Motion passes, amendment is adopted. Representative Roy, you recognized?
I would move HB 1067 to OTP as amended.
That's seconded by Representative Conley. Does anyone wish to discuss the motion?
I believe we've discussed it enough. Thank you.
This time, the matter will now be put to question. If you are in support of the motion of ought to pass as amended, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy? Representative Burt? Representative Rhodes?
Yes.
Representative Green? Yes. Clerk votes yes. Representative Testerman? Representative Lang? Representative Pratt? Representative Marston?
Yes.
Representative Harriet Gathright? Representative Schultz?
Yes.
Representative Rung? Representative Bourdonnais?
Yes.
Representative Perez?
Yes.
Representative Newman?
Yes.
Representative Bolden?
No.
Representative Conley?
Yes.
Representative Klein Knight? Representative Bradley? Chairman Abbas?
Chair votes yes.
17-1, 3 not voting.
Anyone wish to move for consent? Would it be a minority report? Majority report? At this time, we'll now close the public hearing. Excuse me, we'll now close the executive session on House Bill 1067. The committee will be in recess to 9:45.
At this time, I call the committee to order, and we will be opening the public hearing on HB 1577FN. And the chair recognizes Representative Abbas to introduce the bill.
Thank you, Mr. Chairman. Thank you, members of the Criminal Justice and Public Safety Committee. I'm here to introduce House Bill 1577. This bill may look very familiar. It was part of Senate Bill 122 that was championed in this committee by our friend from Keene. And it did pass, but during the committee conference, there was some issues with I think the word used was an omnibus bill that led to the downfall of this policy. So this isn't the entire portion of Senate Bill 122, but particularly involving victims of human trafficking. It captures that scope of the bill. And the primary function of this legislation was that when someone is being a victim of human trafficking, that they will be exempt from certain prosecutions. Particularly, they'll be exempt from crimes other than violent offenses, is the crux of what this bill would do. I'll defer any questions when we discuss this during the executive session. And thank you for accepting my testimony.
The committee now calls Joseph Ebert, New Hampshire State Police.
Good morning, members of the committee. My name is Joe Ebert. It is E-B-E-R-T, and I am a captain with the State Police overseeing our Investigative Services Bureau, which is our Detective Bureau. I've submitted my pink card today with just informational or really a comment that we wanted to make on this. In general, we are supportive of the bill. We, of course, don't want to see anybody who has been the victim of a crime then be charged with an offense as a result of it. Having said that, if I can direct your attention to line 6 of the bill before you, where it speaks about any individual who at any point in time was the victim of a severe form of trafficking in persons offense under 22 U.S.C. And it's the last portion of that line where it says whether or not the offense was prosecuted that we at least wanted to bring for conversation. That seems like a very difficult bar to try and attain. If you are looking as to whether or not you're going to exempt somebody from a criminal offense, how would you prove or disprove that? So we wanted to bring that forward as a point of conversation, and I also wanted to mention that I've spoken with members of the Victims and Survivors Coalition, and we are more than happy, and it seemed like everyone was willing and receptive to the notion of perhaps amending the language moving forward. Having said that, that is my testimony this morning. I'm more than happy to answer any questions that you may have.
Representative Newman, you're recognized for a question.
Well, thank you, Mr. Chair, and thank you for taking my question. Could I just, I read whether or not an offense was prosecuted is, to paraphrase, is either was or it wasn't. So could you clarify for me how that might be changed and why it needs to be changed?
Yes, so thank you for the question. I guess the way I was looking at it is if prosecution is taken on a given charge, then there is a clear and defined record, or there should be a very clear and defined record of what took place in that incident. So without that prosecution taking place, perhaps there is a record of it, perhaps there's not. If you were to later be talking to somebody who said, well, 10 years ago I was a victim of this crime, but there's no documentation of it, it would be very hard to either prove or disprove that notion. And that's really what we were getting at. We're looking at how would you be able to support or not support the notion of what was being said to you if there wasn't an official proceeding that took place.
Just for clarification, I have a question. So I just want to reiterate what you're saying. So were we talking about a defendant, you would be able to run a triple I and you'd see whether or not he's even if it wasn't prosecuted. But there's no record anywhere of defendants, is that correct?
Correct. And again, I just
I
want to
mean,
make sure.
excuse me, victims.
Yeah, victims. Defendants, there certainly is, but with victims, it's not as clear and defined. But I just want to make sure that I come across the committee in the right way in saying that, in general, we are very supportive of the notion of this particular bill. We just want to make sure that we don't we aren't put in a position at a later date to not be able to prove or disprove a portion of it.
Representative Newman?
Thank you. And just based upon the discussion that you had with Representative Roy, it really, and I wasn't thinking of it this way, it really is it's hard to prove the veracity of someone who says they were prosecuted or they had this crime happen to them. Is that a correct interpretation?
It is, thank you, sir. It is difficult to prove if somebody says that something happened to them, if it wasn't prosecuted or if it wasn't investigated. It becomes very difficult if somebody says, a period of time ago, this occurred to me, and there's no documentation of that offense. Thank you.
Thank you.
There being no further questions, thank you. Oh, excuse me. Oh, I didn't see you over there, Representative Pratt. My apologies. Go ahead.
So that same statement is also in line B, whether or not the offense is prosecuted, the end of that also.
And again, thank you for pointing that out, Representative. That is just language we would seek to clean up as the bill hopefully moves forward.
Too vague. Okay, thank you.
There being no further questions, thank you for your testimony.
Thank you very much.
The committee now calls Tory Neville.
Good morning, Mr. Chair and members of the committee. Thank you for the opportunity to testify today. My name is Tori Neville, and I am a core member of the New Hampshire Human Trafficking Collaborative Task Force. New Hampshire's Human Trafficking Task Force was first established by New Hampshire Senate Bill 194 in 2007 to research the issue in our state. And for the past decade, we have evolved to focus as well on casework, training, and outreach. We are a group of law enforcement officers, victim service providers, attorneys, state agencies, and community stakeholders who respond directly to human trafficking in the Granite State. This multidisciplinary team is steered by stakeholders such as the Coalition, Homeland Security, New Hampshire State Police, and the U.S. Attorney's Office. Today I am here to provide educational background on HB 1577 and how it intersects with anti-human trafficking work in our state. Like many of our community members, before I began my work here on the task force, I had no idea how much this crime impacts our state. I quickly learned after I joined that the second ever federally prosecuted case happened right here in New Hampshire. Last summer, I collaborated with our team when a trafficker was sentenced to 21 years in prison for trafficking children and adults in our state, using drugs to entrap them. We are continuously identifying and interviewing potential victims who have been connected to us through local police departments, crisis centers, and more avenues. In that spirit, I would like to offer some background relevant to HB 1577. First, you should know that there is a victim-offender duality that exists for many of the survivors we work with. Sometimes drugs are used as a tool of coercion to suppress victims from fighting back. Sometimes victims are forced by traffickers to commit crimes such as theft or selling drugs. Sometimes traffickers even use their victims to recruit further victims. And traditionally, these criminal histories stick with survivors long after they have managed to escape their traffickers. They label them like scarlet letters, preventing them from moving forward in society, getting a job, renting a home, and building new and healthier relationships. The first point I would like to discuss is that this bill codifies a largely de facto practice in our state that we do not criminalize and punish victims. Currently, defendants can meet the burden of proof showing duress by a preponderance of the evidence. Moreover, if someone is forced to commit a crime that has commercial elements, that would actually qualify them as a victim under the state and federal definitions of labor trafficking, for example, being forced to sell drugs. Besides our own practices, this bill is also consistent in spirit with federal and numerous other state legislation, such as safe harbor laws. These laws prevent minors, so any child under the age of 18, from being prosecuted for prostitution, and directs juvenile sex trafficking victims to non-punitive specialized services. Here in New Hampshire, we also use juvenile diversion courts across the state and a growing number of adult diversion courts to provide a place for victims to heal and exit trafficking situations without carrying the burden of criminal histories with them. In October, we provided training to these programs across the state on screening and referrals for potential victims ending up in their programs. We have started piloting an anonymous tip and screening form with Manchester Drug Court, Grafton County Alternative Sentencing, and Merrimack County Diversion, already leading to several reliable tips. The legislator also passed legislation last year that brings all juvenile defendants with high scores on the Adverse Childhood Experiences Assessment into these programs. We hope this catches potential victims who are falling through the cracks, giving them more opportunities to heal and work together to remove them from these dangerous situations. In conclusion, this bill provides codified language to what we know to be best practices and currently seek to emulate in our state. Victims should not be criminalized. They should be allowed to heal and have opportunities and inclusion in our communities. Thank you, and I am very happy to take any questions.
Representative Bourdonnais.
Thank you, Mr. Chair. Thank you for taking my question. Previous testimony indicated that sometimes our people are not necessarily prosecuted of the crime. Is it ever possible, are sex trafficking crimes not prosecuted because they're not sufficient evidence?
Unfortunately, there are a number of reasons why it's very difficult to identify and prosecute these crimes. Just off the top of my head, I can tell you that we saw hundreds of tips coming in about trafficking in the state and only moved forward with a handful of arrests and prosecutions. There's the issue of evidence for when somebody is in a situation like that. There's also potentially issues of distrust where, victims are told that they are criminals and that, the police aren't going to help them. So then they don't know necessarily that they can come forward and receive that help.
Follow up.
Thank you. So is there any evidence, or should I say documentation, that such a crime exists but was not prosecuted?
We do have some very dedicated law enforcement that looks into all of the tips that we receive. So I can tell you they're members of Homeland Security, New Hampshire State Police, and Merrimack County PD at this point, as well as collaboration with local police departments. So we do have some basic, tips that are coming in and some basic investigation and reports that are run for any tip that we do receive.
Thank you.
There being no further questions, the witness is thanked for her testimony.
Thank you.
You're welcome.
The committee now calls Lynn Charlotte. And a reminder, if you have written testimony, please submit it.
Okay. Am I on now?
You are.
All right. I just got to please start over. So take two. Good morning, Mr. Chairman and members of the committee. My name is Lynn Chalette. I'm the executive director of the New Hampshire Coalition Against Domestic and Sexual Violence. We are the umbrella organization for the 12 community-based crisis centers that serve approximately 15,000 victims of sexual and domestic violence every year. And I am here to speak in support of House Bill 1577. I had planned to share the history of the bill with you, but the sponsor did an excellent job, so you're all up to speed on the fact that you have seen this language before. In terms of the current language in front of you today, when we look at the state's human trafficking laws, specifically RSA 633-7, this law has successfully worked to allow victims of human trafficking to vacate convictions for charges that are brought against them as a direct result of them being trafficked, while also maintaining important safeguards to make sure that traffickers can be prosecuted whenever it's possible, as your questions have raised. This bill creates the right balance in terms of maintaining the legacy of these two important goals. And the way that it's achieved in this language is by inserting the language, the word direct, to ensure that any crimes that are sought to be vacated are directly related to the human trafficking that someone experienced. And it does a second thing as well, which ensures that the crimes that are vacated are nonviolent crimes. The second thing that's really important and helpful about this legislation is it acknowledges the intersectionality that happens for human trafficking victims. It's consistent with the spirit of our current law, which is to protect victims from being prosecuted for something that they likely had no choice in because that conduct was so closely linked to the human trafficking they experienced. However, as we said, victims who also commit violent crimes should not receive blanket immunity for anything they have ever done, and this language appropriately narrows that, that exemption from prosecution. In the human trafficking field, as you heard from the prior witness, we recognize the victim-offender intersectionality. And what that means is that we as a society should consider the coercion, the force, or the fraud that a victim of human trafficking may have experienced when determining whether or not they are culpable for an offense. Under our current law, human trafficking victims can already vacate nonviolent crimes, which was a provision that the coalition supported and helped pass. So we believe this bill strikes the right balance for victims of human trafficking who deserve opportunities to vacate crimes that were committed as a result of their being trafficked. I'd also like to respond to Captain Ebert's comments. The coalition stands ready to talk to any partners about any language that may be needed to be addressed moving forward. I will say that when you look at that provision, it does provide that there would be a hearing related to vacating a crime, and that there would have to be a finding by the court by a preponderance of the evidence that the underlying crime was committed as a result of human trafficking. So there are some protections built into the language now, but the coalition is prepared to work with the sponsor and other allies to move this bill forward. I'm happy to take any questions. Thank you.
There being no questions, thank you for your
Thank you
testimony.
very much. I'll leave the mic on.
Committee now calls Melissa Brotto.
Good morning.
Morning.
Thank you so much for permitting me to testify. My name is Melissa Bruto. I'm an attorney and an advocate for survivors of human trafficking. I have been an attorney for 15 years. I helped to write and oversee the initial implementation of New York's vacator law in 2010. New York was the first state in the country to have such a vacator law. I have also had the honor and opportunity to train attorneys throughout New York State and also to talk to legislators throughout the country about the creation and implementation of their vacator laws. So I have a pretty significant amount of experience in overseeing the creation of these laws and also the implementation on the ground from an attorney, a practitioner standpoint. We were able to pass an expansion of our Vacator Act just in last year, in 2021 in New York, that permitted expansion to vacate crimes committed as a result of being trafficked, both for people that are forced into sex-related labor and also non-sexual labor. So we also saw an expansion of our vacator, and we're very proud of that because we truly believe that survivors of human trafficking need a fresh start. In terms of the comment related to Captain Ebert, I would just like to note, as somebody that has really been on the ground for over 10 years in both practicing these cases and training other attorneys to litigate these cases, that I have never seen that point being raised in any state that I've worked in, and it's never been an issue. There are a myriad ways that somebody can prove that they are a victim of human trafficking. In fact, if you look at Section D, the petitioner shall not be required to provide any official documentation because, as previously stated by other advocates, that can be really difficult, and very, very few cases are actually prosecuted. Incredibly few. I want to just make that very clear. However, there are many, many ways, in fact, 8 are listed here, ways that people can prove that they are in fact a survivor of human trafficking. So, that is fully built into the law. So I just wanted to make that incredibly clear. And that prosecution is certainly by no means the best way to prove it because they happen so infrequently and not because of the fault of survivors. Thank you so much.
There being no questions, thank you for your testimony. Is there anyone else wishing to speak who has not signed up to speak? Seeing no one, I will close the public hearing on HB 1577. And 11:15, 10:30. The committee will be in recess until 10:30.
2019, and then
Yes.
Representative Conley,
yes.
Representative Klein Knight,
Yes.
Representative Bradley, Representative Abbas,
Chair votes yes.
20 to nothing, one not voting.
The motion passes.
I'd like to make a motion to put on the consent.
So moved. With the Representative Klein Knight, will you be drafting the majority report?
It'd be an honor, thank you.
And thank you again for your efforts with this. And I'll just state for the record, if I'd known, I had the awareness at the time, I would have definitely asked you to co-sponsor this with me, and I apologize for not doing that.
It's okay, thank you, Chairman. All that matters is that this passes for the people.
Agreed. This time, we will now close the executive session on House Bill 1577. At this time, we will now open the public hearing on House Bill 1340, relative to the definition of domestic violence and relative to criminal convictions for domestic violence. Representative Abramson, you are recognized to introduce your bill.
Thank you, Mr. Chair, members of the committee. I am Representative Max Abramson here again for House Bill 1340. Yesterday, relative to the definition of domestic violence and trying to make the state definition of domestic violence match the federal definition. I did speak with people from the Department of Safety yesterday, and we agreed that there were still a lot of issues that had to be worked through. And so we're asking you to hold on to this for interim study. But it is your bill now. You're welcome to do what you choose. There were two main motivations for the bill, and then there's also because it opens up a can of worms, it did create a complication. The complication from some members of the committee is that they wanted to maintain the ability of someone to get a domestic violence restraining order against someone. So that was a complication that isn't solved by the bill. And so we felt that the bill needed to be held on to get additional work. I'd hoped to get a committee amendment in by today, but we haven't had enough time to work out all the details. The first problem addressed by the bill was a few months ago, the gun line was kind of overloaded. Every time there's a new president elected, whether they're Republican or Democrat, there's been a huge surge, a huge flurry of new gun purchases. And one of the problems that exists is when we have a different definition for domestic violence, that it forces the gun line because of federal background check rules. Our state gun line, our state police have to contact the courts and look at the specific disposition of every single prior restraining order or prior domestic violence case to see if it might prevent somebody from buying a firearm. And that's because the definition is different. The other problem is because we use a much, much broader definition for domestic violence. It's possible for two family members or two siblings to get into a fight, and it can turn into a domestic violence case, whereas it wouldn't in most other states. So we're trying to essentially have one bill that will kind of fix everything without taking away an individual's ability to request a restraining order against someone if they feel that there's still a violent situation going on. So for that reason, and because the bill is going to need more time and it's going to need to be reopened, I'm asking that the bill be referred for interim study. And that's all I have on 1340.
Rosemary Rung.
Yeah, thank you, Mr. Chair. Representative Abramson, a question. You're recommending interim study. Why not ITL? Because interim study and ITL are probably going to have the same outcome.
Refer for interim study. Well, we agreed that the bill opens up a lot of issues. ITL usually provides some kind of hint or indication that there's nothing worthwhile in a bill to be observed or dealt with. We refer bills for interim study on the Commerce Committee because we feel that there's something worth looking at, but that we want the sponsor or sponsors to come back next year with a different bill that might try to solve a problem differently. Most of the bills that are coming into commerce right now are getting referred for interim study because there's some value there. There's something worth looking at. But it's going to need something structurally very different for next year's bill.
Thank you.
And of course, you want to get input from members of the committee before actually reintroducing another bill.
Representative Bourdonnais?
Thank you, Mr. Chairman. Thank you for answering my question. I'm not too happy with the idea of interim study. How long would it take you to redraft the bill to your liking?
Well, definitely more time than, between now and executive session. So it's interim studies for reintroducing a bill next year. So that would give us another year to work on the details.
Thank you.
Representative, the chair may inquire, if there were to be a redraft, I understand it's not complete, but can you explain perhaps what the spirit of that would look like?
That's to deal with, for me, that's to deal with a future problem of, you get another president or even another governor, and there's a huge flurry of gun sales, and that tends to overload the gun line. So that's a future problem. And the other problem, which may require a separate bill, which is that you could have cases where you just have family members or people living together and they get into a fight, a physical fight, and what would normally be prosecuted as simple assault, it gets viewed as a domestic violence case. I don't think that was the intent, to have two brothers fighting each other and both of them end up with felony convictions, or both of them end up getting domestic violence convictions, where they wouldn't in that particular case in most other states.
So if I understand you correctly, your concern is that the two siblings were to get into an altercation, each of them could be charged with domestic violence. Is that
correct? Or even just being a domestic violence case, it can create problems for the gun line.
Representative Klein-Knight?
Thank you so much, Chair. If you could clarify, you're more concerned with holding up the gun line than you are with protecting domestic survivors from abuse?
We're not supposed to debate the witness. And
Okay,
that's a separate
I
matter.
have an actual question. On line 4, it says physical force. In 5, it says deadly weapon. Are you concerned that you have narrowed the definition to domestic violence to just physical?
What page was that? Page 1, line 4 or part 4?
Line 4 and 5.
Some of those right now, with or without the bill, would be a felony. So criminal threatening is usually a felony if you threaten someone with an actual deadly weapon. But domestic violence laws usually just automatically elevate cases to felonies just by virtue of being a domestic violence case. In other words, we're opening up a whole can of worms by introducing this bill. And once you start opening things up, then there's a lot of work that needs to be got into. I knew that when I introduced this bill, it was opening up a can of worms, but I'd hoped that I would have time to work with the Department of Safety to go over all those issues first. And we spoke and agreed that just referring this for interim study and letting the committee go over those issues, open up those issues right now before bringing in a bill next year would be the appropriate approach.
Thank you. The witness is excused.
The committee now calls Richard Head, New Hampshire Judicial Branch.
Morning, Mr. Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We had two points that we wanted to bring up for today. One is that there is a domestic violence task force that the Chief Justice has put it together in December. Those meetings are ongoing. The task force is anticipated to come up with recommendations on legislation as a result of their meetings. Today, for example, is a public hearing. They're going to be taking public input this afternoon. And the full expectation is that coming out of that task force, we're going to see recommendations on legislation that we would expect would be part of some bills coming up next session. So this bill, if nothing else, seems premature before we can bring together that kind of evidence and the testimony that's being developed in that context. So, for example, in the task force that's meeting, we have on it judges, county attorneys, service providers, legal assistants, victim witness advocates, coalition, criminal defense attorneys, members from Dove, CASA, private attorneys. It's a fairly broad spectrum of individuals involved in that task force, and they are doing a fairly deep dive into a wide variety of issues. So at this stage, we would suggest that putting together a single bill relative to the definition of domestic violence that would narrow the definition as compared to what we have today without having heard the input from the task force may make this bill premature, may also lead to confusion, because if a bill like this, and now I understand it would be put into interim study, but once you start creating, a series of movements in the definition of domestic violence, you create a significant risk of confusion, both in the public, and in terms of how these statutes are being interpreted over time. And then finally, there are a number of statutes that use the term abuse and domestic violence, and as those terms diverge, you create additional opportunities for confusion where how you would start to interpret those two words or those two phrases in different statutory contexts can lead to some significant unintended consequences without really evaluating all of the statutes that use these terms. How are they used? How have they been defined by the courts? And it just seems like a process that's best suited for the task force to really do the deep dive. So with that, I'd be happy to answer any questions that the committee may have. Thank you.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking my question. Speaking for myself, I agree with you. This needs a lot of work and study. This task force you spoke of, are there any legislative members on this task force?
I do not. Hold on. I do not believe so, but I'm just double checking. My list does not have any legislative members.
Follow-up.
You're recognized for a follow-up.
Is the purpose of this task force to recommend legislation?
The purpose of the task force is to evaluate. They have a number of questions, and it's on the court's website is a sort of list of the charge that they have. And you may hear from some of the other speakers as to some of the specifics, but some of those do involve legislative changes if ultimately those are needed in order to, as part of their evaluation of those issues, yes.
Interesting. Okay, thank you.
If the chair may inquire with the question, so would changing the definition of domestic violence disrupt? Do you believe that would disrupt the efforts of the task force?
I think it would disrupt the efforts of the task force and create some significant potential confusion among advocates, among those in the public who may be impacted by domestic violence, and create a time in which the courts are now interpreting domestic violence differently over a period of short windows of time if next year it were to change again, all of which could lead to potential damage and harm.
Thank you for taking my question. If I can also inquire, will this task force put together a report? Would you be able to have that report forwarded to the committee?
Absolutely. I can certainly ask anyway. I'm not a member of the task force, but can certainly make sure. Certainly any report that they issue is going to be made public and distributed, but certainly I assume the legislative body would get a copy.
Thank you. Representative Newman?
not knowing how your committee, your task force is set up and how they get members or how they get that input, do you know of any way that task force might be able to get, as they consider these things, get input from legislators as opposed to writing a report and then the legislators crafting legislation based on the report, which would seem to be much more timely?
I mean, certainly today, there is an opportunity for anybody to provide input. They do have a way of written testimony to be submitted to them at any time. The task force was created by the Chief Justice following an incident that occurred at the end of last year. An internal report was issued, and that's available on our website relative to that incident. And then there seemed to be, in light of circumstances, a need to do a much more in-depth evaluation of domestic violence issues generally. So this task force was created by the Chief Justice in order to really do that deep dive. Currently, he doesn't have sort of a separate mechanism for legislators, but I can certainly talk to him about that.
Representative Newman, recognized for a follow-up.
Thank you, Mr. Chair. So a legislator or legislators that have proposed legislation like to be considered as a bill could submit that information to the task force for them to consider it so that they would understand maybe the direction that the
Certainly
legislation wanted to go in.
Absolutely.
Thank you.
And certainly anything could be submitted, and anybody who has thoughts or input certainly can. And if you go to the Supreme Court website, the task force does have its own website. If you drop down through the links on the Supreme Court website through committees.
Representative Klein Knight, you're recognized.
Thank you, Chair, and thank you so much to the witness, basically answering all the questions that I still had, the same questions as my colleagues. Just to narrow the scope, one last question, basically, would you be willing, even though you're taking a broad look at all domestic violence and how it relates to the current laws, would you be willing to take a look at this language during your meetings?
So to be clear, I'm not on the task force. I'm not a member of it. Anybody who has suggestions or input, I think would be it would be filed through the committee. The chair of the committee is Justice Hans Marconi, but I think going through the portal that's on through the committee website is the better way of approaching it. I certainly am not a member of the committee.
Representative Klein Knight, you recognized for a follow-up.
Thank you. This pertains to members that I've previously spoken to. Is anybody aware that there's actually a public hearing for that very task force at 1 p.m. today that they can attend and bring forth this language?
I'm sorry, I misunderstood the question, I think.
I just want to notify everybody, just because this is an important topic.
At the conclusion of the witnesses testifying, I'll recognize you to make a statement. Thank you. Representative Bordner, you recognized for a question.
Thank you, Mr. Chairman. Thank you for your testimony. Can you reiterate what the name of this task force is?
It is called the Domestic Violence Task Force.
All right, thank you.
I'm happy to circulate a link to the committee website, to this committee as soon as I'm done here.
Thank you. Thank you for your testimony.
Thank you.
The committee now calls Andrew Livernoir.
Good morning, Mr. Chairman, members of the committee. Thank you for hearing my testimony this morning. My name is Andrew Livernois. I am the Belknap County Attorney, and I'm here in opposition to this bill. I think this is a very bad bill. I should say before I begin that I have had an opportunity. Yesterday I sent an email around to all of the other 9 county attorneys in the state, and I heard back from 7 of them. Of the 7 I heard back from, they all are opposed to this bill. The other 2 I didn't hear back from, but so 7 out of the 9, so 7 out of the 10 of us are opposed to this bill. I've submitted written testimony in opposition to this bill, and so I will not go through my entire written testimony at this point. I do want to highlight a few points, however, of specific concern that I have. One is what this bill will do in terms of a person's criminal record and what is recorded on their criminal record. As it stands now, let's say you have a situation where somebody engages in an assault on someone where there is serious bodily injury. And if it's a stranger, that gets recorded on a person's criminal record as simply second-degree assault. But if it is a boyfriend and girlfriend who are in an intimate relationship, that gets recorded on that person's criminal record as second-degree assault, domestic violence. If this bill were to pass, that would no longer be the case. Because this defines domestic violence to only be misdemeanors, oddly enough, then that second-degree assault charge would not be listed on someone's criminal record, as I read this bill, as domestic violence. It would simply be simple assault. This is very problematic because as a prosecutor, it's important to me to be able to look at a person's criminal record and see whether there's a history of domestic violence on that person's criminal record. That's important information for me to be able to decide about asking for bail, preventative detention, what sort of sentence I'm going to ask for, whether to ask for a batterer's intervention or some other sort of anger management program for this person if they're convicted. So that's important information that is now going to be lost if this bill were to pass. The other problem with this bill is I think it makes it very confusing in certain cases as to whether the police can make a warrantless arrest. So currently, in order for the police to be able to make a warrantless arrest for a crime that was not, for a misdemeanor that was not committed in their presence, it has to be abuse and a domestic violence relationship. But because this bill would detach the definition of abuse from the definition of domestic violence, there will be cases where a crime is abuse but is not domestic violence, and the police will not be able to make a warrantless arrest. So, for example, again, a boyfriend and girlfriend who are in a domestic relationship but don't live together, and an assault happens in that case, the police will not be able to make that warrantless arrest within 12 hours. That's a bad development. So, in sum, I think this is a bad bill. I think it causes a lot of confusion in the law. In an area where there's already some confusion in the domestic violence laws, this makes it worse, not better. And I think it's bad for victims. It's bad for the criminal justice system. So I ask you to please vote it inexpedient to legislate. Thank you. Oh, and I'll take any questions. I apologize.
Thank you for your testimony.
The committee now calls Chief Dave Goldstein, New Hampshire Chief of Police Association.
Morning, Mr. Chairman, members of the committee. For the record, my name is David Goldstein, and I'm the police chief in the city of Franklin. I've been a police officer for more than 42 years. And for 23 of those 42 years, I was a member of the New Hampshire State Police. For the last 18 years, I've been a police chief in 2 municipalities. During my tenure as a member of the New Hampshire State Police, I was assigned to the Major Crime Unit for more than a dozen years. During that time, I was involved with the investigations of over 100 homicides. Now, the reason that I can say I was involved in that many homicides as opposed to the actual investigations was because my primary responsibility in those days was crime scene. And we had a fledgling crime scene unit that went from case to case to case, if you will. So we actually worked more cases than most of the detectives in the unit. In concert with the national average, at least 50% of those murders were domestic violence related. The oldest domestic violence victim in one of my cases was a woman in her 80s, and the youngest was a girl who was 10 weeks old. The latter was a domestic mass murder here in Concord in 1991. And if I'm not mistaken, the only domestic mass murder that we've had in our state's history at least for the past 40-plus years that I've been on the job. James Colbert murdered his 30-year-old wife and his 3 daughters, 2.5 years old, 1.5 years old, and 10 weeks old. And, I'm here today to testify in opposition to HB 1340 for the New Hampshire Association of Chiefs of Police. I serve as the chair of the Legislative Committee for the Chiefs. Your chiefs are deeply committed to ensuring the safety of all victims of domestic and sexual violence, and we are just as dedicated to our responsibilities to investigate such offenses. This legislation will make it harder for law enforcement to do our jobs and only create confusion when it comes to investigating crimes of domestic violence and making appropriate arrests. I'm going to go a little bit off script here for a moment and share a war story with you. I started my career with the Derry Police Department in 1979. And in those days, we didn't have half the statutory issues that we have today to protect the victims of domestic violence. One night, I was working on patrol, and a young woman was brought into the hospital who was the victim of domestic violence. Her live-in boyfriend had beaten her to within an inch of her life. He'd thrown her down a flight of stairs, he'd kicked her, he'd punched her, even hit her with a suitcase. And I took the report as best I could, because as you can well imagine, she was being treated medically at the time, and I arrested the assailant. A month later to the day, she came back and recanted her statement. Now, in those days, we were too ignorant to understand the mechanics of what went on with domestic violence victims. And since she came back to recant the statement in front of me, she just committed a misdemeanor in my presence, what's known as an unsworn falsification. I arrested her. I will stand before you or sit before you as I am right now and tell you how embarrassed to this day I am that I did that. But that's the way things were done in those days. Let's not go back to those days. Let's keep it the way that it is. We believe that the changes proposed in this bill dangerously restrict the ways in which victims can seek relief that they need. By way of another example, a short time ago, there was a horrific case in which a woman was shot by her ex-partner in a murder-suicide attempt. This occurred only a few weeks after the woman had been denied a protective order. Since then, a task force has been convened to look into these issues, and we do have a representation. The chiefs do have a representation on that task force. And we're looking to actually expand the definition of domestic violence. Any efforts to do the opposite should be met with an immediate ITL. Thank you, and I'm happy to answer any questions you might have.
Thank you, Chief, for your testimony.
The committee now calls Steve Andres.
Good morning, members of the committee. My name is Stephen Endres. I am an assistant county attorney in Merrimack County. I've been a prosecutor for over 20 years, and I'm actually on the Domestic Violence Task Force from the Supreme Court. Attorney Halverson, the Merrimack County attorney, was unable to be here today. He did prepare a letter, which he asked me to read. He writes, "Today I read the prepared text of testimony Belknap County Attorney Andrew Livernois will submit on January 21st, 2022, concerning House Bill 1340. My schedule does not allow me to be present for the January 21st public hearing on this matter. However, I do want to ensure my concurrence with the comments of County Attorney Livernois is on the record with the committee." He writes, "I urge the committee to vote House Bill 1340 as proposed as inexpedient to legislate." I agree with those concerns. I agree that House Bill 1340 is a bad idea. As Attorney Livernois points out, the definition of domestic violence would be limited to misdemeanor level offenses. The bill actually has 9 sections. Section 2 talks about first-degree assault, but first-degree assault is a felony, so you could never have domestic violence first-degree assault if you limit the definition of domestic violence to misdemeanors. The same is true of the 3rd section, which talks about second-degree assault. You could never have second-degree assault domestic violence because second-degree assault is a felony, and this definition would limit it to misdemeanors. The 4th section talks about reckless conduct, which can be charged as either a misdemeanor or a felony in New Hampshire, depending on the facts of the case. However, the definition talks about the threatened use of a deadly weapon. If you had the threatened use of a deadly weapon, reckless conduct would be a felony. And again, as we've talked about, you can't have felony domestic violence because the definition would limit it only to misdemeanors. Section 5 talks about aggravated felonious sexual assault. Again, that's always a felony in New Hampshire. Since the definition of domestic violence would be limited to misdemeanors, you could not have domestic violence, aggravated felonious sexual assault. Section 6 talks about felonious sexual assault. Same thing, that's always a felony in New Hampshire, so you could never have domestic violence related felonious sexual assault. Section 7 talks about sexual assault, which is in fact a misdemeanor. So it would be theoretically possible to have domestic violence related sexual assault under this bill. However, if you go back to that definition and you need an attempted use of physical force or the threatened use of a deadly weapon, we would never charge a misdemeanor sexual assault with physical force or the threatened use of a deadly weapon. Those would become aggravated felonious sexual assault. So that section, while it would be theoretically possible, in reality, you'd probably never have domestic violence misdemeanor sexual assault. The 8th section talks about kidnapping. Kidnapping, again, is always a felony in New Hampshire, so you could never have domestic violence-related kidnapping because domestic violence would have to be a misdemeanor. The last section, stalking, section 9, stalking generally is a misdemeanor in New Hampshire. It can be charged as a felony under certain circumstances. But I have a hard time imagining how you would have stalking that had the attempted use of physical force or the threatened use of a deadly weapon without that being charged as a felony criminal threatening, a felony assault, or some other type of felonious conduct. Interestingly, Representative Abramson indicated that his concern was siblings engaging in a fight and that being recorded as domestic violence. Certainly in New Hampshire, if two siblings were engaged in a fight, they could be charged with domestic violence under RSA 631-2B. This bill wouldn't change that. This bill doesn't reference RSA 631-2B in any way and wouldn't solve the problem that he's indicating exists. I don't feel that's a problem, but that's perhaps his opinion. The other comment I would make is that he indicated most domestic violence cases are charged as felonies. That hasn't been my experience. Domestic violence under 631-2B, which is the New Hampshire domestic violence statute, the majority of crimes under that statute are in fact misdemeanors and are in fact charged as misdemeanors. Be happy to answer any questions if you have any.
Thank you. The witness is excused.
Thank you. I just submit.
I'll take your written testimony.
Excuse me, Representative Marston, you're recognized for a question. My apologies.
Thank you, Mr. Chairman, and thank you for your testimony. I'm under the impression you would like to see us ITL this bill.
Yes.
Follow-up?
That wasn't a question, but you're recognized for a question.
Thank you. I'm a little bit confused. The sponsor wanted to maybe go to an interim study, and you're talking about an ITL, and I understand the two differences. What I will withdraw. Thank you. I got it.
Thank you.
The witness is excused.
The committee now calls Lynn Charlotte.
Good morning, Mr. Chairman and members of the committee. My name is Lynn Charlotte. I'm the Executive Director of the New Hampshire Coalition Against Domestic and Sexual Violence. We have prepared extensive written testimony to provide to the committee today, and since we're hearing a lot of The similar concerns about this bill, I'll abbreviate my comments. We are here in strong opposition to this bill and do urge you to ITL the bill. It does significantly narrow the definition of domestic violence and frankly rolls back decades of work in terms of responding to victims of crime. There are 3 significant reasons we encourage you to ITL the bill. And the first is how significantly it narrows the definition of what domestic violence is. And Assistant County Attorney Endres really demonstrated that clearly for you. I don't think we can debate the pervasiveness of the problem of domestic violence in our state. In the last 4 years, our 12 crisis centers have served over 6,000 child and adolescent victims, nearly 50,000 adult domestic and sexual violence victims. They have answered over 266,000 hotline calls, and our 11 emergency shelters have provided over 160,000 nights of shelter for people fleeing danger. What we know is that domestic violence is a pattern of coercive behavior. And New Hampshire addressed this fact in 2014 when we passed what we often refer to as Joshua's Law, identifying the very specific crime of domestic violence. And you heard from County Attorney Livernoy this morning why that is so important. It helps prosecutors in making really critical decisions in their cases. Also under this bill, another concern we have that I don't think folks have touched on this morning is that for a charge of domestic violence to occur, the victim would have to provide proof of a physical threat by a deadly weapon. This completely ignores decades of research of what we know about how domestic violence happens. And it doesn't always involve a weapon, and often there are very nuanced ways that offenders threaten, coerce, and terrify victims of this crime. The second reason that this bill is problematic is that it would limit access to protective orders in the state of New Hampshire. As you've heard from other witnesses this morning, under current law, there is a broad definition of who may apply for a protective order: a family or household member or a current or former intimate partner. By narrowing this definition, we are ignoring what really happens in many domestic violence cases. Sometimes it is committed by a sibling. Sometimes it is committed by an aunt or an uncle. It is important that those victims have access to the remedies that exist under New Hampshire law. It's already difficult to get a protective order. If we look at the data in New Hampshire, between 2018 and 2019, there were 8,000 petitions filed for domestic violence protective orders. Only 38% of those final petitions were granted. If we narrow the definition of who is eligible, we are denying all of those people access to that remedy. And the third and final reason, we echo what Chief Goldstein presented to you today. If we remove this definition of domestic violence and we narrow it so much, it will take away from law enforcement the ability to identify some of the most risky crimes. In New Hampshire right now, we use a tool called the Lethality Assessment Program. It's often referred to as the LAP program. It is a questionnaire that law enforcement officers use when they respond to the scene to identify victims at the highest level of lethality and to link them immediately to crisis centers. Keeping this definition, the existing definition of domestic violence, is imperative to support law enforcement officers who are responding to the most lethal cases, the ones where victims are most at risk of being killed. So in conclusion, we strongly urge this committee, for all the reasons you've heard this morning, to vote ITL on House Bill 1340. Thank you, and I'm happy to take questions.
Representative Bourdonnais.
Thank you, Mr. Chairman. Thank you for testimony. Is your coalition represented on the task force for against domestic violence?
Thank you for the question, Representative. Yes, we are. We have 2 staff members who are serving on the task force, and I am one of them.
Thank you.
Representative Burt, you're recognized.
Thank you, Mr. Chairman, and thank you for your testimony. On the 8,000 cases that were filed, could you get us, email us, what was, approximately, what percentage was filed for X number in this particular situation, and why they were granted and not granted?
Thank you for your question, Representative. So the courts produced data on the protective orders, and you heard from a representative of the courts this morning. The number of petitions that have been granted and denied is summarized in the biannual, I always forget, every 2 years, Domestic Violence Fatality Review Report. Unfortunately, we do not have data, though, available in New Hampshire on why those orders were granted or denied. We can certainly get you broken down by court, how many were granted and denied, but the reason for those is not available to any of us, although it's an important conversation to have.
Representative Burt, you recognize for a follow-up.
Thank you, Mr. Chairman. It is very interesting to have. So is there a way that you could just send me the link so I could go and study it myself and maybe research it a little different, because that number really does intrigue me.
We can absolutely send you the report. It's available on the Department of Justice's website, but I'm happy to get the link to the committee.
Thank you. I appreciate your help.
Thank you. The witness is excused.
Thank you very much.
The committee now calls Erin Jacina.
Good morning, Mr. Chairman and members of the committee. My name is Erin Jacina, and I direct the Domestic Violence Advocacy Project at New Hampshire Legal Assistance. We represent low-income victims and survivors of domestic violence, sexual assault, and stalking in their high lethality protective order cases, as well as their divorce and parenting cases. And when I refer to high lethality cases, those are the cases where there is significant risk to the victim that they will be killed or seriously harmed by their abuser. I also want to mention that I am a member of the Domestic Violence Task Force. In 2021, NHLA represented 207 victims and survivors and spent over 9,500 hours representing victims and survivors in New Hampshire courts statewide. I am here today to testify in opposition of House Bill 1340. The terms domestic violence and domestic abuse are often used synonymously and interchangeably. This bill seeks to amend RSA 173B1 to include a new and separate definition of domestic violence. If interpreted literally, New Hampshire would then have a definition for domestic violence and another definition for abuse. That's one particular outcome if this bill is passed. Another outcome is that this amendment to the statute is purposely changing the definition of abuse so that both domestic violence and abuse should be used interchangeably. If that is the case, this bill has far-reaching negative impacts which will make it harder for victims to seek and obtain protection from our courts. Under current law, victims may seek an order of domestic violence protection if one or more of 8 particular acts are committed or attempted to be committed against them. That includes criminal threatening, destruction of property, harassment, interference of freedom. Those are some examples of the 8. If House Bill 1340 were to pass, it would limit the qualifying acts to the use or attempted use of physical force or the threatened use of a deadly weapon. Therefore, those cases where the victim was not physically assaulted or held at gunpoint may no longer be eligible for protection under our law. As I've just mentioned, there are crimes which do not involve physical assault or a weapon, but are no less serious in terms of placing a victim in fear for their safety and well-being. Passage of HB 1340 takes protections away from victims. It does not enhance their safety or make it easier for them to access much-needed relief from our courts. For these reasons, NHLA respectfully asks this committee to vote inexpedient to legislate on House Bill 1340. Thank you for your consideration, and I'm happy to take any questions.
There being no questions, witness is excused. Thank you for your testimony.
Thank you so much.
Representative Perez, you do have a pink card submitted. A member is, I suppose, more than welcome to testify. I will assure you that if we will likely have an executive session today, and I'll be sure to recognize you to speak. So, I'm just asking, with me saying that, do you still wish to testify? Because the other concern is, I don't recall if you are testifying, you're not supposed to ask questions. I don't recall if you asked any witnesses questions. That's so, I don't know the answer to that. But I assure you, I will recognize you to speak during an executive session. At this time, we can now close the public hearing on House Bill 1340. At this time, we will now open the public hearing on House Bill 1388, relative to an unsolicited disclosure of an intimate image.
The committee calls Representative Nutting Wong.
Representative, the floor is yours.
Thank you. Thank you, members of the Criminal Justice Committee. I'm here. Thank you for the opportunity to introduce HB 1388 relative to the unsolicited disclosure of an intimate image. This bill would criminalize the unsolicited disclosure of an intimate image, otherwise known as cyberflashing. If it were to become law, it would make the unsolicited sending of genitalia via electronic device between adults a misdemeanor. The action of sending these images is harassment with nearly no recourse for the people who receive them. When I receive a message or email, I expect to have a conversation, not send graphic images with no warning. These images are often sent without prior contact purely to get a response. When I've received one, the advice I'm given is to block the sender. Indecent exposure is a similar crime with often no proof, with similar recourse as I'm asking for in this bill. But a cyberflasher can send many more images at a time, and the proof is right there. I have included 2 studies done by YouGov in the UK, which have not surprising results. Almost 20% of women in the study have received these types of images. 62% of them were received by text message. This is a pervasive, growing problem that is only going to get worse as time goes on unless we put a stop to it now. On the back of my testimony, I've also included the full law, so you can see how it fits in there. I know before there have been concerns about the effects on children. That's already illegal, so I just wanted to be able to see the larger picture. With that, I conclude my testimony. Thank you so much.
Representative Marston, you are recognized for a question.
Thank you, Mr. Chairman, and thank you for your testimony, Representative. My question is this: how do we enforce this law if we make this law?
Thank you for your question. If we were to place this in law, I believe if you were the victim would have to report to the police what happened.
Thank you.
Representative Lang, you're recognized.
Thank you, Mr. Chair. Thank you for taking my question. My question is similar to Representative Marston's, but it has to do with accidental disclosure, right? So I'm intending to send it to someone who I have a relationship with, but I accidentally typo the number. Now, I knowingly transmitted the message, but it went to a person I didn't intend it to go to, and that person reports me. How is that dealt with in this law?
Thank you for your question. As I'm not a lawyer or a police officer, I am not really qualified to answer that question, but hopefully you would apologize, and hopefully that would solve the issue. And maybe double check.
Representative Klein-Knight, you're recognized.
Thank you, Chair. Thank you, Representative, for taking my question. Do you believe that a complaint or any other line of formal, basically if you go to the police and you complain about anything, there should be a investigation conducted, so this would probably fall under that realm to solve all those issues?
Thank you. I think so, yes. I imagine, again, not a lawyer, not a police officer, I imagine you would go to the police, say, hey, look at what happened, and you'd have the screenshots right there because it's a text message. And yeah, that was how it be handled.
Representative Rung?
Thank you, Mr. Chairman, and thank you for taking my question. In the bill, it states an image. Does that include like video images or just screenshot still images? I'm thinking of a situation where there may be someone who's on a Zoom call or whatever, and then, you know, starts displaying some of this behavior. And it's not, I don't know, would it be defined as an image even if it was like video or?
Thank you for your question. I believe so, yes.
Okay, thank you.
Representative Bolden?
Thank you for taking my question. So I'm looking at the area of criminal code that would be changed by your bill, and it looks like the Indecent Exposure law was put into place in 1971. I know that that's before the internet existed. So is it your intent essentially to expand the indecent exposure laws that we already have to include flashing that occurs over the internet? Is that your intent?
Yes, thank you. That is my intent.
Thank you.
Representative Schultz?
Thank you, Mr. Chair. I actually think that my question has already been answered. I apologize.
Representative Conley?
Thank you, Mr. Chairman. Thank you, Representative. The question about the Zoom is actually one that I don't think had come up during prior testimony on this bill. It sounds like it might be covered, but was that the intent to include that as well? So that all manner of unwanted exposure in this way would be covered?
Thank you for your question. When I first submitted this bill back in 2019, 2020, Zoom wasn't really that big of a thing. So back then it was not quite my intent. However, since then, yes, I'm really happy that I would hope that this includes that as well. Actually, we've had an experience where my mother's church group got Zoom flashed or whatever you call it, where, you know, these nice old ladies doing Bible study did get hacked, and it was very disturbing. My mother was telling me about it, and I was like, wow, I have a bill for the past 2 years. But yeah, I do hope that it would cover that. However, it would be a New Hampshire thing, so it might get a little difficult there. But
Representative Burt, you are recognized.
Thank you, Mr. Chairman, and thank you for your testimony. I think I remember this bill. I almost think this question was asked, so I'm asking it again if this is the correct bill. What happens if a boy and a girl are together, they're sending pictures back and forth, and then one of them breaks up with the other, and then the other one goes to the police? Look what they're sending me. How do they deal with that? So that way there's, you know, not that backlash of, you know, I'm going to make you pay, and this is how I can do it.
thank you for your question. Again, consent would have to be determined by the police officer or the court. But I think it's pretty clear in the bill that consent does need to be there. So whether that's implied or not. I'm digging myself a hole in this question.
All right.
But yeah.
All right, thank you.
We understand that the witness is not a police officer. Representative Bolden.
Thank you for taking another question from me. And I understand that there are other areas of law that determining whether a crime has occurred depends on the ability of law enforcement to determine consent. Do you know of some examples of other areas of law where police would have to determine whether consent existed before they can begin an investigation? for example, sex assault,
Yeah, I was thinking
things like
felonious
that.
sexual assault at first. But yeah, crimes like that.
So
But
maybe
yes,
like,
other crimes do exist based upon consent, and they seem to handle them pretty well.
thank you.
And if I may, the chair may inquire, if I understand your testimony correctly, there are certain situations where there can be human contact that is not illegal because the contact is consented to in one way or another?
Yes. Thank you.
Thank you. Representative Klein Knight?
Thank you, Chair. Thank you for taking my question. This is more of just language question, real quick. On line 6, it says who is 16 years of age or older. I feel like we should strike. It should be all people. I'm not. I don't know if you're amenable to a amendment.
Well.
But I'm unless they're baby pictures, I feel like we might get into trouble here.
The back of my testimony, I did include the full law. Currently, if you're 16 years or younger, it's already illegal. So if you wanted it to be all the same, then sure. But it already is
Oh,
covered.
thank you for clarifying that.
Representative Rung?
Thank you, Mr. Chairman, and thank you, Representative. This is sort of a follow-up to my earlier question and to others that have been asked. But in the current legislation, is the term image defined?
Thank you for your question. I'm reading it now, and I don't think it's especially defined more than it already would be in the law.
All right, follow-up, Mr. Chair?
You recognize for a follow-up?
Okay. Do you think it would strengthen this bill if there was a definition of image so that it could specify any, not just a still picture, but a video image or a live in-person communication, you know, like a electronic communication like Zoom?
So I appreciate the question. I think the reason why we wrote it the way it is just to keep everything kind of the same, so there's not a special law for adults like and children, so that way the definitions are similar. So maybe, but the reason why it's written the way it's written is to fit well with the law affecting minors.
Okay, thank you.
Representative Schultz?
I think I am going to ask that question. Thank you, Mr. Chair. Isn't it true that there already are laws on the books involving images in cases of child pornography?
Thank you for your question. Yes, and I believe they would also be part of like the revenge porn law, which I believe is one section down from the current one.
Representative Bolden?
Thank you for taking what I hope will be my final question. Do I understand correctly, because I'm looking at, again, the criminal code that you gave us, the existing law. Do I understand correctly that under current law, sending an image, and the word image is in the existing law already in use, that sending an image to someone under 16 is a felony, and there's currently no penalty for sending an image to someone who's 17, 18, or 99, and do I understand correctly that you're seeking to make it a misdemeanor to send an image, a word that's already used in the current law, to someone 17 or older?
Thank you for your question. Yes.
Thank
correct.
you.
Thank you for your testimony. The witness is excused.
The committee calls Lynn Shalit.
Good morning, Mr. Chairman and members of the committee. Lynn Shalit with the New Hampshire Coalition Against Domestic and Sexual Violence. We've also submitted written testimony, and your questions have addressed most of the issues. We are happy to be here in support of this bill and want to thank the sponsor to her commitment. There was a similar bill introduced last session, and we were able to work with law enforcement, prosecutors, the ICAC task force, and advocates across the state to come up with this language. I think Representative Bolden, you summarized effectively what this bill does. It recognizes that sending these images right now to a minor under the age of 16 is a felony, and it fills in a loophole in the law and addresses that it would be a lower level offense to send them to someone 16 years or older. Receiving an unsolicited sexual image is disarming. It could be frightening. It could be alarming. And it also is often used by abusers as part of the grooming process. So we believe that it's appropriate for this to be an offense, but at a lower level than it would be if the images were sent to a minor. So I'm happy to take questions. I'm also aware that Assistant County Attorney Endres is still here because I know you all had a lot of legal questions about how prosecutors would respond.
Representative Klein Knight.
Thank you so much, Chair, and thank you for taking my question. And this might, if you can answer this, maybe the next speaker can. Roughly, do you know how common this is?
I don't have any data on that, unlike the earlier questions about data, but certainly in terms of survivors that we serve at crisis centers, we know that technology is used more and more in stalking and harassment to terrify and frighten victims, but it's not really something we have specific data on. But technology is a tool that is used more frequently all the time.
Representative Newman.
Thank you, Mr. Chair. I'm thinking off the top of my head about, as I'm reading this and the discussion that talks about images to people who are less than 16 years old. And I'm thinking about where a 15-year-old is intimate with a older teenager or another teenager, and they send pictures to their friends. I don't know if that happens, but I presume that it may happen. Would that person be charged with a felony?
If it was a minor who actually distributed that, if it would be appropriate, I'd prefer to defer that question to the prosecutor because I think he'll have the most comprehensive knowledge on that.
Thank you.
Representative Rung.
Thank you, Mr. Chair, and thank you for taking my question. We had a situation in Merrimack a few years ago where a teacher sent images like this to a student who was 16 or older. And I was wondering, are there any statutes on the books that you're aware of that would provide more criminal charges in that situation? Because I could see you could have a high school student that's 17 and is under the power of a teacher, but that still would only be a misdemeanor with this legislation.
Absolutely. We did submit a list of the related statutes on the back of our testimony, but again, I think the prosecutor is probably the person best suited to answer the questions about charging decisions.
Okay, thank you.
Thank you for your question, though.
Thank you for your testimony.
Thank you, Mr. Chairman.
You're excused.
The committee now calls Steve Andres, Merrimack County Attorney's Office.
Good morning again. My name is Stephen Endres. I'm an assistant county attorney in Merrimack County. As I indicated earlier, I've been a prosecutor for over 20 years. So I'd be happy to try and answer some of the questions about how we would go about prosecuting these cases or what we would do in certain scenarios. I can indicate the scenario of if you texted someone a picture intending to text it to one person and it accidentally went to another person, I would personally look at that scenario very much in the same context of if I had an individual who said, I was going to surprise my wife by jumping out naked in front of her and happened to have jumped out naked in front of the wrong person. I would look at whether or not that was reasonable. I would look at the two phone numbers. I would look at whether they were a digit off or completely different. I'd look at whether there was evidence that this person had done this in the past, and all of that would go into a decision of whether or not to charge the person. I don't know if anybody has any questions.
If the chair may inquire,
Yes.
and thank you for your testimony, and thank you for taking my question. Is there any opinion on the, so it says on line 7, it references an image. Would it change the intent or how this law would be applied if it's an image or a live video feed, if we maybe just tighten that up?
I don't see that as.
My question is, would that be necessary?
I don't know that that would necessarily be necessary, because I don't know that a live stream would not be considered an image, at least to me. If somebody was live streaming themselves fornicating to a person over 16, I don't know that I would say, well, it wasn't an image because it was a live stream.
Representative Burt, you were recognized.
Thank you, Mr. Chairman, and thank you for your testimony. Again, back to that scenario of if a couple are together and then they break up and they come and see you or the police and then see you.
Right.
You know, look what's happening. How are you going to determine that there was consent or there wasn't consent?
I think what it would come down to is when I look at this statute, we would have to prove beyond a reasonable doubt at trial that the recipient has not indicated by speech or conduct that they freely consented to the receipt of the image. So I would look at the background of that relationship. I think that you would likely have the person perhaps saying at one point this was consensual, and if they didn't explicitly then indicate it is no longer consensual, I think we would not be able to bring charges in that case.
A follow-up, Mr. Chair?
Representative Burt, you're recognized for a follow-up.
Thank you. Now, another scenario is I received an email that and it was an attachment. I was not going to open it up because I didn't recognize it.
Good idea.
Yes. Well, well, then I get a text, John, open this email. And the email was from Australia. So when I inquired about that, because I looked into it a little further, I go, this thing's from Australia, I'm not opening it. So when I inquired, it was from somebody I knew, and they have software that don't put them in New Hampshire. It puts them in Australia, and I'm going, how does this happen? So I'm confused on how it happens, but I guess it does. How are we going to enforce this law with somebody sitting in New Hampshire, emailing down to Australia, or that's where the IP goes and comes back?
I think that would be very difficult to enforce under that scenario. But that's something that we face with all sorts of laws, whether it's whether this bill passes or not. That's a problem in law enforcement that we see in terms of people harassing, threatening, committing financial crimes, committing online fraud, is that people are able to hide their actual location or their IP address through software.
Representative Klein Knight.
Thank you, Chair. Are you saying that's what investigations are for?
Certainly that would be part of the investigation. I think you could certainly frustrate an investigation.
Representative Roy, you're recognized.
Thank you. In reviewing the statute, it talks about images of yourself, but it doesn't seem to cover just random images that could still be offensive. Would that be covered under the gross lewdness part of the statute, or does it the statute perhaps need to include any lurid images? And I know there's been some issues with a definition of pornography to include, for example, cartoons like manga or whatever. What are your thoughts on that?
I think that the language in this statute that refers to an image of himself or herself fornicating, exposing his or her genitals, mirrors the language that already exists in 645.1 with reference to people under 16. I certainly do think that, I don't want to say that there's a loophole, but this statute wouldn't cover sending a picture of another person's genitals. And I think that currently if you sent a picture of another person's genitals to a person under 18, we could conceivably charge that with providing minors with harmful materials, which is, I don't know if I know that statute off the top of my head. I want to say it's in the 500 series. It's in the public justice section. So there is a statute that prohibits exposing minors to harmful materials by sending them a picture of genitals for a person under 18. I believe that's a misdemeanor.
Representative Roy, recognized for a follow-up.
And at the risk of delving into this a little too deep, how, for example, you charge me with sending a photo to someone under the statute, and I say, that's not mine. Are we doing, how do you do that?
I think
Is that a lineup? I mean, how do we?
I mean, I think it would be difficult to prove.
Yeah.
And again, this mirrors language that's already in the statute that prosecutors already have, difficulty proving. I think realistically, though, this is less about random people sending pictures of their genitals to other random people.
Yeah.
And I think this is more of you meet on a dating website, you exchange a couple emails, you know who this person is, and they send you a picture and make some comment about, look at my spectacular genitals, and are admitting that this is in fact a photo of themselves.
Which is, if I may.
Follow-up?
I totally agree with the sentiment and most of the statute. I just want to make sure that we make it enforceable. I don't want to pass something that feels great but isn't workable. So if you have a suggestion, we would appreciate it.
You certainly could expand his or her genitals to human genitals or any genitals or whatever language you felt was appropriate for that.
Representative Schultz?
Thank you, Mr. Chair. Did I understand you correctly to say you had a concern about, maybe it wasn't concern, but that you didn't believe the word image would also reference video?
I believe the word image would reference video.
Okay. I agree. Thank you.
Representative Newman?
Did you mention that that image is defined in the current law 645.1?
I don't believe it is defined in 645.1.
Thank you.
Representative Brown?
Thank you, Mr. Chairman, and thank you for taking my question. I don't know if you remember the question I asked Ms. Sholett, but we had a situation in Merrimack where a teacher was sending images of himself to a student who was 16. And with this, is there any statute that you're aware of that would elevate that crime over something, maybe a non-teacher doing it?
I'm not aware of anything that would make it more illegal for a teacher to do that.
Okay, thank you.
Representative Bolden?
Thank you for taking my question. So I know that the questions so far have covered a lot of different concerns about the terminology, with the intent being to extend the indecent exposure law to the internet. Are there any changes that you'd recommend to the wording? And I know I'm kind of putting you on the spot, but if you could say generally.
I don't see any changes that I would recommend. I don't know that this necessarily extends it to the internet. It would extend it to somebody providing it, transmitting it to another person, whether that be through text or email. But I don't think this would necessarily, criminalize someone from putting a picture on their website.
Thank you for your testimony.
Thank you.
At this time, we will now close the public hearing on House Bill 1388. Just for the members of the committee, in a minute or two, we're going to open the executive session on House Bill 1340. At this time, we are now opening the executive session on House Bill 1340 relative to the definition of domestic violence and relative to criminal convictions for domestic violence. At this time, the chair recognizes Representative Klein Knight to make a motion.
I move that we ITL this bill.
It's a motion for any expedient to legislate. Is there a second? It's been seconded by Representative Bradley. Do you wish to speak to your motion?
I have a point, a question for the chair.
Parliamentary inquiry.
Yes. Did you just say Representative Bradley?
I did. She seconded them.
Oh, sorry.
She had her hand
You're
raised.
absolutely right. She did that. I have no question for the chair. I am very sorry.
And I just, for the record, need Representative Bradley to say second. Thank you. Chair.
Could you just repeat the bill number, please?
We are in the executive session for House Bill 1340. There is a motion of inexpedient to legislate. Representative Perez.
Thank you, Mr. Speaker, for letting me speak. I want to speak on this bill. I'm someone who is a survivor of domestic violence. To be honest, I was only 15 years old when I moved here to the U.S. I didn't know the language. I didn't know my rights. I was hiding on a closet when my ex-husband used to hit me. The neighbors used to call the cops, and he used to hide me in the closet, and he used to tell me not to get out of the closet because he didn't want to get in trouble with the cops. So he never got in trouble for domestic violence. This bill, it would take away the rights for victims like myself to be able to put charges to someone like my ex-husband, who not only he hit me, but mentally and emotionally he abused me. He took away my 2 kids because he told me that if I put any charges for domestic violence against him, he was going to take away my kids from me, and he was going to take my right to be in this country. Me not knowing very well the language, I believe him. My son, he was 2 years old. My daughter was 6 years old when he took them to North Carolina. I was afraid to lose my right to be in this country and not be able to see my kids never again. That's something that I wish I knew my rights back in the days, because I feel like he took away the right for me to be a mother and the right for me, for my kids to have a mother. I feel guilty. I feel sad that I didn't have the chance to be there for my daughter when she was growing up. I will support the ITL for this bill because, trust me, in many ways, domestic violence happened, especially for people like myself, when we don't know what is right and what is wrong. Thank you.
Representative Rhodes, you are recognized.
Thank you, Mr. Speaker. I'm sorry, I was following Representative Perez. Thank you, Mr. Chairman. I think the state has worked very hard to be where we currently are with the laws in protecting victims of domestic violence. And I think it is imperative that we keep the measures in place to help these victims, especially considering that we had a very good piece of legislation that would have helped these victims with their abusers, and unfortunately, we were not able to get that legislation passed.
At this time, the matter will now be put to question. If you are in support of the motion of inexpedient to legislate, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Aye.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman.
Yes.
Representative Lang.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. Representative Schultz.
Yes.
Representative Rung.
Yes.
Representative Bourdonnais.
Yes.
Representative Perez.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley. Chairman Abbas.
Chair votes yes.
21-0.
Move for consent.
No objections.
Will there be a majority report? That will be prepared by Representative Bradley. Thank you very much. At this time, we will now close the executive session on House Bill 1340. The committee will be in recess till 12 p.m.
I guess, done in consideration for something else. I guess some people are paying couples to do things online. I'm not gonna mention or go into detail, but technically, it theoretically could be considered money in exchange for sex. So because of the broad way that our prostitution and related offenses are defined, are very broad in New Hampshire, that they could be caught under that scope. So I didn't want to see cases where people are just doing a webcam or doing something like that. They may even be a couple, and they could still theoretically get prosecuted. So this is meant to protect them also. My biggest concern was when I was living in Manchester, I started to see more and more often that sex workers were out in the street. And what happens in most Western countries is they recognize that there's a problem, but they either tolerate it, they decriminalize it, they've legalized sex work, or regulate it in some way in order to get it off the street. And some Western countries have some type of red light district or pink light district of some kind in a commercial setting, but most of them, it's allowed only in the privacy of your own home, and that's just to get the activity off the street, and that's kind of what my intent was. I have had a few people I've known over the years actually get caught up in this who were not engaged in prostitution at all, and they were still arrested, and they were still charged, and they still end up with a criminal record, and they ended up at the Valley Street Jail, even though they were not actually sex workers in any true sense of the word. And the reason is that something as simple as photography can potentially fall under this penumbra because it's so broad. And so what I've tried to do is come up with a very simple carve-out to say that if somebody's just in the privacy of their own home, that we're not going to have enforcement in New Hampshire. Towns do retain the ability to fine somebody $10 on a first offense or $50 on a second-time offense, but I can't imagine too many towns or cities actually going ahead and trying to enforce this violation level offense. They could if they really, really needed to, or if they really, really, if there were public support for that. It's a local control issue, but I didn't think that it's a good use of public resources to go into people's homes and try to punish them for what they're doing in the privacy of their own home. We have seen that when prostitution is made illegal in general, that it ends up out in the street, and that because of the arrests, women, mostly women working, end up having to get a pimp, and the pimp is usually where the abuse comes in. Some serial killers have admitted that they target prostitutes because they found that they're easier targets, that they're isolated. We passed an immunity law a couple of years ago through this committee to guarantee that women who are working in that field are able to go to the police without risking prosecution. But it's not a completely universal immunity that they have. They still are actually risking being arrested if they come forward and report a crime. So for that reason and others, I felt that the bill was necessary. I tried to come up with every possible compromise that any member of this committee has ever brought up where they had a concern that there wasn't people weren't using condoms, or they weren't using protection, or that some people weren't getting tested. So I tried to accommodate every possible concern that people had, and it's in this particular version of the bill, it's limited just to one's own home. So you still wouldn't be allowed to solicit outside. You wouldn't be allowed to advertise under the bill. You wouldn't be allowed to even the issue of promoting it on the internet. You still wouldn't be allowed. That aspect of it isn't legalized or decriminalized. The only thing that's allowed under this, the only thing that's decriminalized is people engaging in any type of sexual activity in their own home. So, and with that, I'll take questions.
Representative Rhodes, you are recognized.
Thank you, Mr. Chairman. I feel like there's a smorgasbord of questions here. So Representative, so if a person hires, if somebody hires a person and then they're supposed to go have, you know, this test, I'm sorry, a person hires somebody, uses a false name, because I'm sure they probably don't want, you know, their name to be all through the newspaper. So in this legislation, you have about the person having to be tested yearly for sexually transmitted diseases. And how exactly would this sex worker go about notifying their clients that
They can just take an annual test, and if they really want to post it on the wall, like, you know, when you go into the chiropractor or dentist's office and they have their license, I'm sure that they could post it on the wall if they wanted to, if anybody objected or if anyone raised a question about it. I think if somebody were actually going to go and use, you know, hire this kind of service, that they should probably use a condom regardless, just as a matter of safety. And in fact, 90+% of the time, people are doing that right now. But I've never even considered, you know, someone going in and then wanting to check the license on the wall for that. I don't know. If somebody wanted to, they could post that up on the wall in their bedroom, I suppose.
Representative Newman, you are recognized.
Thank you, Mr. Chair. Thank you for taking my question. I just want to make sure that I am correctly reading this bill as it's written in front of me. And you can correct me if I'm wrong. And everything on page 1 and everything on page 2, except for the one portion that is parentheses E, unparentheses, where it's lined out, and it lines all of that line out, and then it continues the line out into the F there, means that that is the only part of the current law that is taken out. And the way this is written, then paragraph that used to be F is now paragraph E. But that's the only language that's taken out of the bill, as I see it, and the rest is the bill.
Right, that's a strategy that's used by legislative services when they, instead of just completely rewriting the whole thing, they take on the first part, all they've done is remove part E, which is knowingly permits a place under the person's control to be used for in violation of a subparagraph. And then there's a new paragraph added, which is on page 2, starting on line 6.
Thank you. Yeah, I see that. Thank you very much.
Representative Marston.
Thank you, Mr. Chairman, and thank you for taking my question. Is there any or a large amount of law enforcement going into private homes for this type of an arrest?
Right now, I don't know of any. The only city I know where there was a lot of enforcement of prostitution laws was the city of Manchester when I lived there, and what they were mainly going after was what was going on the street. I believe they were also going into lodging. And the reason that they were doing that was only because there was a federal grant that said that the city had to spend the money enforcing prostitution laws. That was the only one that I was aware of that was on a large scale.
Thank you.
Thank you, Representative.
Did you have a question? I saw a hand go up over there. I didn't know if it was. Oh, okay.
The committee now calls Jean Pride.
Do you mind if I take this down? It's a little easier to speak.
Thank you.
Good morning. Thank you very much for the opportunity to testify to this bill to Chairman Abbas and Vice Chairman Roy. I appreciate it very much. My name is Jeannie Pride, and I am from Swansea, New Hampshire. I'm here to testify against House Bill 1176. I've taught high school for 29 years, mostly at Conant High School in Jaffrey, New Hampshire, and teaching child development has always been my passion. For the last several years, I've been teaching a human development course through River Valley Community College. Also, I'm on the board of RISE for Baby and Family of Keene, which provides intervention for children 0 to 3. I'm not here to represent these institutions, but just to indicate my concern for children and their welfare. There are others here who are testifying today that have much more expertise on the concerns regarding this bill, but allow prostitution to be legalized. What I want to concentrate on is the harm to children. This bill states that by keeping prostitution illegal, we are contributing to the improvisation of single mothers and their children. The idea of a single mother having men in her home while her children are there is very dangerous. Darkness to Light is a nonprofit whose mission is to end child sexual abuse. They cite research that children who live in a single parent and has a live-in partner are the highest rate of sexual abuse. They are 20 times more likely to be victims of sexual abuse than children who live with both parents. Research fellow Jeremy Summit cites reviews of more than 70 research reports providing overwhelming evidence that girls living in non-traditional families are sexually abused by stepfathers, partners of the single, remarried, or partner mothers, at many times the rate of abuse by a biological father. If there are men coming into the home who have no connection to the children and are coming only for the purpose of sex, this, I believe, can be a dangerous situation for the children. I have here for each of you some information on what is called PACEs and ACEs. What ACE is adverse childhood experience. This has been pretty well accepted at most schools and how we treat children these days. What ACEs is childhood experience that harms children's developing brains so profoundly that the effects show up decades later. They cause much of the chronic disease, mental illness, and at the root of most violence. This is my greatest concern for these children, that in these situations, they would experience ACEs due to these men coming in their home. The ACEs can not only be sexual abuse, but hearing yelling, perhaps violence against their mother, and other abuses. There are means in which our state and schools help single mothers get the education they need for their families that would be much healthier for them and their children. This is what we need to be promoting. The course I teach, Human Development, is a requirement at River Valley nursing program. A large percentage of my students are single moms. I tell them this is the best thing you can do right now for your family. These are the things we should be promoting. I strongly urge that you do not support this bill. Thank you.
There being no questions, thank you for your testimony.
The committee now calls Darlene Pollock.
Good morning, Mr. Chairman, ladies and gentlemen, members of the committee. I appreciate your hearing me today. My name is Darlene Pollock, for the record, and I'm a resident of Raymond, New Hampshire. I'm also a juvenile sex trafficking survivor from here in New Hampshire. This bill specifically outlines the experience that I had, because it doesn't just say in your home, it says or where you're legally allowed to be. My first trafficker groomed me at 13 years old. At 14 years old on my birthday, he sold me for the first time in his apartment, in his bed. I was just turned 14. You hear me, right? The day before I was 13 years old. About a year and a half later, this same buyer rented an apartment where he had a stable. A stable is a term that we use when you have more than one sex-trafficked child or persons. There were 3 of us girls at the time when I was living there, and he furnished us generously with narcotics and a lot of generosity went on if we were very compliant. If we were not, we were threatened very seriously, not only with violence, but with being turned out into the street, etc. It wasn't a violent experience in that place for me, but we did suffer a lot of deprivations. If we didn't comply, we didn't get any food. He would go away on vacation and leave us with nothing. We weren't allowed to leave, or we would not be allowed to come back. This situation only, again, lasted a few months. But I was trafficked for 4 years. And I want to just let you know that because I'm sitting here and I look okay, you might think, well, that was just a childhood experience, it's no big deal. But I have suffered my entire life with all kinds of symptoms, from chronic illness and pain constantly to symptoms similar to post-traumatic stress disorder, nightmares, inability to make decisions. I own nothing because I can't make long-term decisions. I have suffered on and off with substance abuse and with alcoholism. I have a lot of trauma responses in my life that I manage with a great deal of diligence and a lot of struggle. This is not a small thing. The representative introduced this bill saying in one's own home about 15 times. But if you look at that bill, it says or in a place where they're legally able to be. That's a big difference from in one's own home. I ask you to vote inexpedient to legislate on House Bill 1176, and I'll now take questions, but I would ask you to please keep them to the testimony given here today. Thank you.
There being no questions, the committee appreciates you sharing, and thank you for your testimony.
Thank you.
The committee now calls Tricia Grant.
First, I just want to say thank you for allowing me this opportunity to speak. I, like my survivor sibling before me, am a survivor of sex trafficking. I was trafficked as a 15-year-old child in and out of Maine, New England, all over the place, in people's homes. I was brought into people's homes, so this bill just floors me. I can't even, I've had 3 days to kind of process this, and I'm shaking. Like, this is insane to me that there are people even considering doing this. And I'm just going to continue on with what I have written, but I was brought into people's homes. I was brought into hotels, legally operated strip clubs that are still fully functioning, all against my will. I did not want to be at any of these places. I was told that if I did not go to these places, that the people who had trafficked me would have my son taken away from me because I had been living on my own since I was 12 and living in my own apartment, going to school and working and taking care of my son at 14 years old. These men knew what my biggest fear was, and they exploited that. They told me that if I did not do everything that they told me to do, they would have my son taken away from me. Walking alongside survivors of all ages and the long-term impacts, like Darlene had stated, are some of the things that I myself have experienced and the other survivors that I walk alongside. And just because we are removed from that situation does not mean that it all of a sudden just goes away. The long-term impacts of people being trafficked, exploited, and who have experienced prostitution, even if they believe that they have been there as a willing participant, these effects still remain. Some of those are CPTSD, anxiety, struggles with self-worth, suicidal ideation, suicide. I myself attempted suicide so many times, I don't even remember how many. The last suicide attempt I had was when I was 23, and I had to learn how to walk again. All of this because of the trauma that I experienced as a child and my experience being exploited. Legalizing prostitution has never been an effective strategy to keep people safe because there is absolutely no way to know who is there by choice and who isn't. How old a person is, nobody was asking me to see my state ID or to see my birth certificate. And I can guarantee you, even if they had, my trafficker would have found a way to have a fake ID made. So there is absolutely no way to guarantee that somebody is there by will and of age. And to just kind of speak to the fact that somebody stated earlier that it's the responsibility of the person who is selling sex to be tested once a year. Sometimes those tests don't become clear for 6 months, 9 months. Sometimes it just floors me that that was even presented. But the thing that floors me most is that what about the men who are coming in to buy, or what about the people in general who are there to come in and buy sex? What's the responsibility on their end to be tested? I'm going to end just by stating that it took me 16 years to even know that there was a name for what happened to me, and that it wasn't my fault. I never spoke of what happened to me for 16 years. I sat in that silence. I sat in that pain, terrified to go into grocery stores because I might run into somebody who paid for me 16 years ago. That's trauma. That does not just go away. That carries on with people who have stated that they are willing participants and people who were not. So I'm just going to ask you, I'm just going to end on this, please do not let this pass. This is not safe. It is not a way to help people. As much as people can try to claim that it is, it just simply is not. It took me another 1.5 years after I learned that there was a name for what happened to me and that it wasn't my fault to say something. And since then, I have been able to be a fierce advocate for myself and for other people who are still walking through this, and for people who remained in their bondage of silence even longer than I did. Please do not let this pass. I will at this point take any questions anybody has.
There being no questions, the witness is thanked for her testimony and sharing.
The committee calls Marissa Folkans. I'm sorry if I mispronounced that.
Hi there, thank you for hearing me. My name is Marissa Fernandes. I am the National Director of New Hampshire Traffic Free Coalition, and I live in New Hampshire, and I wanted to speak today in opposition to this bill. I've been working in the anti-trafficking world for 13 years, and I'm horrified to see how much this would set us back as a state and as a nation if we were to condone a bill like this that has so many things that would harm women inside of it and put them at greater risk of being trafficked. So one of the things that is, the London School of Economics did a big research paper, and they found that wherever sex was legal, the demand for it increased, and sex trafficking increased. So it's just simple economics where there is a demand, you have to have more product. And so that's what's happened when you look at like Las Vegas or Germany, certain places in Germany and the Netherlands. This is a big issue because people know they can go there and buy sex, and if you're an entrepreneur or if you know you can make more money as a result of this, situations like Darlene's will happen more often because they want to be able to get as much money and have as much product as they possibly can to meet that demand. It also would make New Hampshire a sex tourist destination, which would put the women that I work with at greater risk and the people we're trying to protect at greater risk. And I also, as a mother with 3 boys, I don't want my children growing up thinking they can purchase another human being for sex. And I think it really sets us back. As a movement, like even as from a feminist perspective, to think that women can be bought and sold and that they're an object to fulfill a specific gratification of another individual. So I pose it on that level as well. So some of the other points were made, but yeah, I think I asked for 2 minutes, but yes, I would just ask you to consider, is this something we want in our state? Is this something that we want to condone? We want our young children growing up thinking that especially women can be bought and sold. It's predominantly women who are in prostitution. We need to be creating exit strategies. This is not the best we can do for the women of New Hampshire. Thank you. Oh, if anyone has any questions.
There being no questions, the witness is excused. Thank you for your testimony.
The committee calls Pamela Kiley and Janet Carroll. New Hampshire Coalition Against Domestic and Sexual Violence.
Good afternoon, Mr. Chair and members of the committee. My name is Pamela Kylig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. You've heard from us several times this morning, so I won't reiterate who we are, but we are strongly opposed to HB 1176, which would have an extremely harmful impact on the victims of sexual assault and human trafficking in our state. And I am grateful to have my colleague, Janet Carroll, here today, who is going to provide some educational information around the major concerns we have with this legislation.
Good morning. For the record, my name is Janet Carroll, and I'm the statewide Sexual Assault Nurse Examiner Program Director with the Coalition. There are three main areas that I hope to address in my testimony. One is clarification on what the general court finds in this legislation, impact that this legislation will have on victims of sexual assault and human trafficking based on the experiences they have now, and the illumination of the comprehensive healthcare needs victims of sexual assault and human trafficking have as it relates to the risk and prevention of sexually transmitted infections, or STIs, and HIV. First, from a medical perspective, the article that was listed, which references researchers at UCLA and Baylor University who discover a reduction in rape and STIs during a time when indoor prostitution was inadvertently decriminalized in Rhode Island. I've included that article for your reference. From a medical perspective, it's really important to note that this paper has not been peer-reviewed, but rather circulated for discussion and comment purposes only. In addition, the authors clearly state, quote, "We are not claiming to have identified the causal channels which link decriminalization," unquote, to the reductions that they discuss. Second, I'd like to address the suggestion that criminal offense of sex work is leading to the pandemic of sexual violence. Sexual violence, including human trafficking, occurs across all socioeconomic populations, regardless of an individual's choice of employment. It is forced, manipulated, or coerced sexual activity in which the perpetrator uses sex to inflict humiliation, exert power and control, or use the victim to attain sexual gratification without regard to the victim's consent. The responsibility for that sexual violence lies squarely at the feet of the offenders, who are rarely, if ever, held accountable. Holding offenders accountable by legalizing their activity is unfathomable and extremely dangerous. To further suggest that in holding offenders accountable, we are in some way contributing to the rate of sexual violence is outrageous and minimizes the very real abusive and traumatizing experience that victims of human trafficking and sexual assault face. The impact, the second area would be the impact of this legislation on victims of sexual assault and human trafficking based on the experiences they have now. I know that members of the Human Trafficking Task Force are here today to address the significant concerns that arise from this legislation, but I'd like to just highlight a couple from someone who frequently provides care to those patients experiencing sexual assault and human trafficking with treatment and care. Okay. Sexual assault, including human trafficking, is already severely underreported, and there are significant bias and victim blaming when the adult sex worker reports sexual assault, which contributes to no reporting or underreporting of this crime when it does occur. When victims feel it is unsafe to report, not only are offenders not held accountable, but the victims themselves do not get the access to treatment and resources that they need. This bill will actually place victims at more risk because it will reduce their access to critical protections and support. Many victims of human trafficking are not identified at all due to the lack of education and understanding about the differences between trafficking and prostitution. This legislation will assist in making it more difficult to identify the victims of trafficking. I routinely care for children and adults who are forced or coerced into providing sex, whether it be for money, food, shelter, or something else. This legislation increases the likelihood that those individuals will be harder to find, identify, and properly care for. The third area, illumination of the comprehensive healthcare needs for victims of sexual assault and human trafficking as it relates to the risk and prevention of sexually transmitted infections, including HIV. Victims of violence and victims of human trafficking present for healthcare in similar ways, but victims of human trafficking are more likely to be isolated, abuse drugs, and have infectious diseases, malnutrition, and complications from poor medical care. Victims of human trafficking have some of the most profound medical and psychological health problems, including sexually transmitted infections, genital mutilation, urinary difficulties, pregnancy resulting from rape, broken bones, burns, concussions, dental problems, and infections, in addition to post-traumatic stress disorder, anxiety, and depression. Victims of human trafficking need timely access to health care and treatment that is comprehensive and reflective of their experiences and the exploitation that they face. Providing this essential care would be nearly impossible under this new legislation, which will only increase the barriers that victims face to accessing the care and support they critically need. It is also in the best interest of the state and its citizens to implement public policy that serves to improve the circumstances of sexual assault and human trafficking victims in New Hampshire. We should be putting forth every effort to address the root cause of violence, not create further opportunities for abuse and exploitation. In conclusion, the realities of sexual assault and human trafficking in New Hampshire have far-reaching consequences for victims in the communities which they live. Victims often experience a lifetime of trauma, including both acute and chronic physical and mental health consequences, and the Coalition and the SANE program believe this legislation will cause greater difficulty in identification of victims and further harm by limiting healthcare ability to provide support and critical treatment.
There being no questions, the witnesses are thanked for their testimony.
Thank you.
We now call Charles Pendlebury, representing MSCO.
Good afternoon, Mr. Chair and members of the committee. My name is Charles Pendlebury. I've been in law enforcement for 10 years, 2 of which I've served on the New Hampshire Human Trafficking Task Force. I am here speaking as a representative of the Merrimack County Sheriff's Office in opposition to HB 1176, which would be detrimental to the safety of human trafficking victims. I would like to briefly share a few facts that we know to be true from our experience to investigate and charge crimes of human trafficking in the state. Identifying sex trafficking is extremely difficult because of tactics used by traffickers. This bill would further complicate efforts to combat sex trafficking. Specifically, law enforcement officers would now lack probable cause to enter a home or building under this new law, as the bill essentially legalizes brothels without any protections for victims of human trafficking. Sex traffickers are known to use violence and intimidation to force their victims into commercial sex. They further brainwash their victims to believe that police cannot be trusted and are only there to wreck their lives. Sex trafficking victims struggle to identify their own victimization. This is a crime that is happening in the shadows. Victims are not reporting this crime because they are under a delusion created by the trafficker that what they are doing is at their own free will. Sex traffickers will use this legislation to convince their victims that this activity is legal. This will only embolden the traffickers to increase their ability to control the activities of their victims. I can honestly say that I've never arrested anyone in my time as a law enforcement officer for prostitution, and currently it is not a common practice in New Hampshire for sex workers to be prosecuted, and in some counties there have been less than 5 cases in the last 3 years. Even if a sex worker is arrested, it is highly unlikely that they will be convicted of the crime, often due to later correctly being identified as a victim of human trafficking. With that in mind, it is very confusing to me as to who we are actually trying to protect with this legislation. Additionally, monitoring the crime of human trafficking is already extremely difficult, and this legislation will make it nearly impossible. I would like to briefly talk about familial trafficking, which to me is up there as one of the most horrendous forms of this crime, where parents and guardians will often trade their child or person they are in custodial care of to fuel a substance abuse addiction or something like that. And to me, if this is passed, it will only embolden them and make them feel they can do whatever they want in their home or place they have legal right with no repercussions. I appreciate your time, and I can answer any questions that the committee may have.
There being no questions, thank you for your testimony.
The committee calls Michael Shively.
Hello, I'm Michael Shively. I'm representing the National Center on Sexual Exploitation. I'm a career researcher, and most of it is applied research in the fields of criminal justice and victims issues. And I'm going to mostly restrict what I say to the factual foundation that was put forward in this bill. There's so many things wrong with it that it's kind of hard to know where to start, and we'd be here all day if I just fact-checked everything in it, but I'm more than happy to provide information like the details later. But I'll just touch over the kind of the lowlights of what's presented and just offer some, counterfacts or a little bit of a reality check on it. Before I get into that, though, there's just a little perspective that I just can't help but think of, it wasn't that long ago when domestic violence was considered a family matter. It's in the home, it's their business. The state has no business wading into homes and worrying about what's going on there. This just seems like we're headed back. It seems like you're taking what is undoubtedly the most dangerous way to make money that exists on the planet. The evidence is absolutely overwhelming that nothing is more dangerous than commercial sex. And it doesn't matter what legal system it operates under, it's always dangerous. And it's endemic. And you can't do harm reduction. It doesn't get reduced, right? If it exists, it's dangerous. Now we're saying, let's take this insanely dangerous thing, and it's private business as long as it's indoors. That's like saying, this family stuff, we can't sort it out, so just let it go, right? So that's the perspective, but there's a lot of research on this. In fact, there are over 700,000 studies and factual reports about it, so it's possible to come out of that avalanche of facts and reports and come up with anything. I can support any conclusion about it. If what you do is cherry pick just the stuff you want, which is what's happened. This reads directly, it's from the playbook of the pro-decriminalization movement, which is a global movement. And actually in that movement, New Hampshire is just a point on a map. And you're being targeted with disinformation. And this factual foundation that's in there, it's directly from the documentation. It's sort of like, going back to the tobacco industry, and if the only thing you listened to was what the tobacco industry said about smoking safety, that's what you have in front of you. So I really can't fact check all of it, but basically everything there, if there are grains of truth, but they're misrepresented, or they're part of a spectrum of information, and it's only one part, and you're not seeing the rest of it. I'll get into a couple of things, but there's no evidence that HIV declines under decriminalization. There's only one decriminalized country in the world. It's New Zealand, right? So what are you going to compare to that to, right? There's just no comps there. There's some estimates, but they're really problematic and they're very speculative. Legalization has not worked in the Netherlands. In fact, the Netherlands has been kicking it around, and they finally recently decided in Amsterdam, we need it out of the city. We've not been able to make this work, and they're pushing it out of the city finally. I can talk about Nevada, I can talk about anywhere it's been legalized. That's not what we're talking about here exactly. This is decriminalization, which is kind of the worst of all worlds. You're not setting up any real protections or systems to try to make it safe, but you're also saying law enforcement is not going to intervene. One thing that I can guarantee you is that if you decriminalize, even if it's just within this limited context of the home, police lose probable cause to investigate human trafficking. New Zealand, which is held up by some as some success story, They just got knocked down by the State Department from a tier 1, which means the best, to a tier 2 country, because they don't make sex trafficking cases anymore. Any advocates groups tells you there are hundreds of child sex trafficking victims in the country. They've made zero convictions, and I identified 0 adult or child victims in the last 3 years. These are State Department reports. The typical sex trafficking case is made because you see prostitution, there's probable cause since it's a crime, and that's when they find out, you know, she looks 20, but she's 14. Or, well, it seems consensual, but as soon as she's away from her pimp, she says, this is not consensual. You lose that. I'll just talk about one study and then I'll stop. That Rhode Island study that was mentioned earlier, here's what happened with that study. Rhode Island, they had this weird little loophole that kind of decriminalized it. It started in 1980. It ended in 2009. What the study did is they looked at these trend lines on health indicators like sexually transmitted diseases. They looked at rape rates, and they picked the year on sexual assault that was an anomaly. It was 49% higher than the previous year, the one that came after it. They picked 2003, and then they ended it in 2009. Well, if you take this freak year that's high, and then say something happened and it ended up lower, it makes it sound like it went down, right? The whole trend line tells exactly the opposite story. So they took out of 29 years time series, they took their favorite 6 years. That's what the study's based on. There's a lot of really horrible research, and then there's some good facts that actually were good research, but if you misrepresent them, they tell the story that really isn't the true story. So I'm more than happy. I could give you more research than you would ever care to look at, and I could support anything I've said, and I'm happy to go point by point in that factual statement in the bill and offer at least another perspective. Any questions?
Representative Newman.
Thank you. Thank you for taking my question. You know, I wouldn't want you to have to go by point, but I'm just curious if your research has anything you could say from your research that deals with Roman numeral 2, which is about the harmful reduction countries. I don't know what that is, and also Roman numeral 6, which just mentions Article 2B of the New Hampshire Constitution. I would be interested in anything that your research showed about, or you can say, based on your research.
Yeah, so there's a trend or a movement in the public health field where, for reasons I could talk about, but it would take too much time, unless you want to. There's a movement to accept decriminalization, and it's mostly driven by the industry itself. And the industry itself, of course, their economic interests are to make more money and keep the industry flourishing. So in the public health world, there's some adoption of this decriminalization idea. And there are a lot of studies, they all look the same pretty much, which is what they do is they go into a clinic and they find that there's astronomical rates of all kinds of horrible things for anyone involved in the sex trade. And then there's an assertion in the study that says it would be great if it was decriminalized, right? That way the police wouldn't harass people. So there's an assertion in there, but there's really no connection between lowering HIV rates or any other health problem other than that assertion. There's one study by Kate Shannon, showed up in the Lancet, super famous, very widely cited, and they said they did an estimate that's based on very complicated statistical models. And I had a conversation with the authors, and I said, was there any data, actual data in your models that showed decriminalization? I wonder how you measure that. Do you take all the criminalized and the decriminalized countries? There's things that I wonder about, and they said no. They had no data on decriminalization. What they did is they plugged in assumptions. And the assumptions used in that study, one, condom use would go to 100%, violence against anyone in sex work, that's their phrase, not mine, goes to 0%, 0% police harassment. Now, what in the world could possibly make those things happen? No population of any kind has a 0% violence rate. But they say decriminalization would produce that. Then, with that assumption, they plug it into this forecast model. You know, so I mean, if you really dig under the hood, there's just, there really is nothing. Like, I thought about giving you kind of a glib answer at first when he said, what's that about? And to tell you the truth, I don't know. You know, I really can't, because there is no evidence that holds up that really substantiates that. Was there another point you wanted?
Yes.
The other point was, do you have anything to say about Article 2A of the New Hampshire Constitution, and if that relates to this in any way?
I can't say. I don't know the New Hampshire Constitution
Thank you very
well
much.
enough for that.
Thank you.
All right.
All
Thank
right.
you very much.
Thank you. There be no further questions.
The committee now calls Caitlin Makis. Macius.
Good afternoon. My name is Caitlin Macias, and I'm here representing World Without Exploitation. We are the largest anti-human trafficking coalition with over 200 United States-based organizations. And we work on creating a world that's free from human trafficking and sexual exploitation, which we believe is a human rights issue that's fueled by gender, racial, and income inequalities. We are guided by survivors of the commercial sex trade whose perspectives are critical in developing just and effective policies. I come to this work with a unique perspective. I work with World We, but I'm also a Latinx woman and a student at the Columbia School of Social Work. I stand here in opposition, or actually I sit here, in opposition of HB 1176 in New Hampshire that would remove criminal penalties for indoor prostitution. This bill and the ideology it represents is a fundamental misunderstanding of the realities of the sex trade and minimizes the lived experiences of survivors of commercial sexual exploitation. It's thoughtless to implement a policy that encourages the sex trade to actually expand during a global pandemic. This bill claims to actually help women and children and members of the LGBTQ community. However, repealing criminal laws that prohibit operating premises for prostitution or operating a brothel will only put those communities in further harm's way. You will actually be giving pimps and traffickers a playground to exploit people. Why? Do you want a violent industry like the sex trade to actually expand? Do you know the realities? Prostitution and sex trafficking are actually inextricably linked and fueled by the demand for commercial sex. Violence is actually incredibly pervasive. Physical, psychological, and emotional abuse that you've actually heard from survivors today, even in the privacy of their own homes. Indoor prostitution is dangerous. No one will be able to see inside these homes. The best example of why New Hampshire should not pass this bill is actually Rhode Island, and you've heard about this today. Rhode Island decriminalized indoor prostitution between 1980 and 2009. As a result, the state became a regional sex tourism hub with high rates of sex trafficking, violence, and extensive criminal involvement, promoting the state to revert back and adopt strict laws against the sex trade in 2009. So by removing these types of penalties, New Hampshire is not protecting marginalized people in the sex trade. You will simply be making it easier for someone to start an illicit massage business or brothel in this state without worrying about penalties. And so now you're asking me, what is the solution? We must take a holistic approach instead. World We and our member organizations support legislation that specifically ensures that people in prostitution do not face criminal penalties, but instead are provided exit strategies and services like safe housing and healthcare. This is known as the equality model. We also support policies that enable people in the sex trade to report violence and other crimes they have experienced to law enforcement without fear of arrest. We know that criminalizing those engaged in the sex trade who are victims of violence and exploitation is harmful and does nothing to prevent human trafficking and exploitation. But we also know that making it easier and less risky for third-party exploiters like pimps and brothel owners to profit off of exploitation of others is actually not the answer. Please oppose HB 1176. Thank you for your time. I also would like to pass around a letter This was actually signed by over 70 survivors. Some of them are from New Hampshire, and some of them are from across the country, and they're survivors of sex trafficking and also prostitution. So if you want to take a look at the letter and read their names, it would make a great deal. Thank you so much.
Thank you for your testimony. That being the last witness, we will be closing the hearing on this. I would like to take a moment to thank all of the witnesses for their vigilance in coming forward today and testifying. And personally, I'd like to apologize that you had to do so. Thank you very much. The hearing is closed.
We'll be in recess until 1:45.
Oh, good. So right outside where she went. Yeah, just to the restroom. Yeah, we'll be right outside. Yeah.
This bill puts so many people's lives in danger. It's an insult to so many different.
The member will suspend. We're not allowed to speak to another member's motivations behind filing a bill. So such an argument would be inappropriate. However, I think the unintended consequences, perhaps, or some of the consequences of the bill you can speak of if it were to pass.
The unintended consequences of this bill would put so many people's lives in danger. And also I want to, for the record, say that sex trafficking is horrible, and people that are forced and taken and forced into this kind of situation, it's abhorrent, and we should take it serious. But there's a difference between sex trafficking and sex work, and people that are professionals and they give consent. And we have to be careful about how we talk about things like this, because we're discriminating against an entire group of people if we don't separate the two. Thank you.
Thank you, Representative. At this time, the matter will now be put to question. If you are in support of the motion of inexpedient to legislate, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy. Okay. Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testerman. Yes. Representative Lang. Yes. Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. Representative Schultz.
Yes.
Representative Rung.
Yes.
Representative Bourdonnais.
Yes.
Representative Perez.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley, excuse me.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley. Chairman Abbas.
The chair votes yes.
20 to 0, one not voting.
The motion passes.
No
Wish to
objections.
move the consent. Representative Harry Gathright, will there be a majority report? Thank you. At this time, we will now close the executive session on House Bill 1176. This time, we will now open the public hearing on House Bill 1400, prohibiting law enforcement from using the scent of marijuana as probable cause for a search.
That's okay.
This time, we recognize Representative Amanda Bolden to introduce House Bill 1400.
Thank you. I'll fill this out and hand it to you when I'm done. For the record, my name is Amanda Bolden. I represent Hillsborough District 12. The New Hampshire Supreme Court has determined that the scent of marijuana alone is not sufficient for probable cause. This was decided as a result of decriminalization, as well as the creation of medical cannabis programs in our state. Literally, the smell of marijuana is not evidence of a crime because it's not a crime in all cases. Even though the Supreme Court has sorted this out for us, as a legislature, we can't rely on case law alone to maintain law and order. I put in this bill because I've learned in my life that many things smell like marijuana, which are not illegal and are not evidence of a crime. For example, I learned last summer that fresh green branches of maple smell identical to marijuana when burned. Skunk spray is often mistaken for marijuana, as well as the popular oil-based fragrance known as patchouli, which can be found in many shampoos, soaps, and body washes. I've also had many experiences in which the smell of marijuana entered my vehicle or my home due to the activity of a person nearby but unknown to me. For example, I've driven behind many vehicles in my lifetime that were driven by someone partaking, and the smell exited their vehicle and went into mine. My windows were down or my vent was open. Additionally, I've had a neighbor who would use marijuana in the backyard, and we kept our windows open because the weather was nice, but we'd have to close them when the neighbor started because the smell would get into our house. And that's a nuisance in and of itself, having to close the windows on a nice day. But it would be a much greater bother if someone else's behavior was used as grounds to enter my property. However, all of these circumstances aside, I want to return to the New Hampshire Supreme Court case law. We can ensure law and order in this state by relying on case law. The courts do not make law, they interpret it. We need to formalize this in statute. We need to ensure that people who are not engaging in illegal behavior and cannot reasonably be suspected of such are secure in their persons, houses, papers, and effects against unreasonable searches and seizures. I'll take any questions. Thanks.
Representative Testament.
Do you mean to forbid the use of the smell of marijuana as one of the parts of probable cause? In other words, certainly a person, a policeman could use marijuana plus a marijuana cigarette or something else, sort of a totality of all the issues that are there. Would that be okay?
I think you're referring to the Supreme Court decision, and that is the intent is to reflect what the Supreme Court's decided, which is that it shouldn't be used as the sole reason.
Correct.
Representative Marston.
Thank you, thank you, Chairman. Thank you for taking my question. What I'm not following in the writing on the bill is you say after Section 10. I can't find a Section 10 in the book. There must have been some new law that came in that hasn't been printed into a book. Is that possible?
Thank you for the question. I have a laptop, so if you just give me a minute. So it says RSA 595A after Section 10. So we look up New Hampshire RSA 595A. Never live blog Googling before. 595A, Section 10. So 595A has 10 sections, so after Section 10, so it would be Section 11. Or it would be, yep, and that's what it says in the first line, 595-8:11. That's what it would be called. Have I answered your question? Would you like to see the RSAs?
Well, that's fine.
The witness and the member, to suspend for a moment. The witness is a member of the committee, so this discussion is more appropriate maybe for the executive session.
Okay.
Thank you. Representative Rung.
Thank you, Mr. Chairman. Representative Bullen, would you believe that in 1982, I got pulled over by a police officer and my car was searched on the suspicion of marijuana because this officer detected a scent. It turned out to be a pinhole leak in my radiator hose, and the smell of burning antifreeze is very similar to cannabis. So in addition to those examples you cited, would you believe that antifreeze is the same smell?
Did you say that it was
Wait.
Can I answer the question?
Is the question that do you believe the smell of burning antifreeze is
I think she was asking if I believe that if that occurred, and I don't remember if you said the 70s, but if it's the 70s, I might have my doubts.
Okay.
That's all. Thank you.
And any additional questions? Representative Harry Gathright.
I asked Karen to print it a little bit ago. I think she'll bring it in soon, or she'll ask me to come get it, and I'll hand it to you.
And the chair may inquire of one question. Is this intent, it says, an officer shall not use the scent of marijuana as probable cause. Are you suggesting just the scent alone would not establish probable cause, or it can't be considered as part of a totality with other considerations?
I think that I already answered that question earlier with Representative Testerman alone.
I apologize if okay, thank you. If I missed the answer, I do apologize to the witness. Thank you. The witness is excused. Representative Testman, you are recognized.
When you stated that it couldn't be used alone and consistent with the Supreme Court decision, if you read, regardless of that, if you read what Representative Abbas was saying, it says you shall not use the scent of marijuana as probable cause. That would tell me that you could not use it at all, not if it's not part of something else. But what do you mean there? I mean, I know what your bill says, but what you said appears to contradict that.
Thank you for the question.
My question is...
He said, what do you mean?
Yeah, what do you mean?
I think I answered that in your earlier question. The scent of marijuana alone should not be probable cause for a search, which is what our house smells like sometimes.
My question, though,
because of the neighbor.
Is that what the bill says?
Last question, Representative Testman.
I believe that the bill says that because it says as probable cause to conduct a search, and it doesn't say alone, but it doesn't say in addition to anything else. So I think that the intent is clear to me. I know that in my communications with OLS, my intent was clear.
Thank you. The witness is excused.
The committee calls the Honorable Jess Edwards.
Thank you. For the record, I'm Representative Jess Edwards, representing Auburn, Chester, and Sandown. I signed in opposition to this bill. I've already learned something, though. I didn't realize that there was a Supreme Court case that spoke to this matter. I would still be tempted to go one of two directions that's different than this bill. I would either not pass this into the RSAs because the Supreme Court decision's already in effect and the court can modify and tweak it, according to future cases, or I would go ahead and amend it so that the word solely is inserted in an appropriate spot to make grammatical sense, so that it's clear that the smell alone, or solely the smell, would not be on its own probable cause. So I listen to the conversation. I just think a simple word tweak could fix it. And I guess I just would also, since this is a criminal justice committee, I just say I really am concerned about the national trend in disrespecting law enforcement and removing powers from them, and it sends a bad message. I think it makes it harder for them to do their job. And we need to hire good people. We need to train them very well. We need to supervise them well. But generally, I think we need to accept that they have a vital role in public safety. So I'll answer questions if there are any.
Thank you, Representative. The representative is excused.
The committee now calls Lieutenant Bill Bright, New Hampshire State Police.
Good afternoon, and thank you for hearing my testimony, committee. For the record, my name is Lieutenant Bill Bright of the New Hampshire State Police. I oversee the Narcotics Investigations Unit for the New Hampshire State Police. A few of my concerns have already been talked about in the previous testimony with this bill. Our concerns are that, there's nothing in the bill that says that it's to be used as a sole source. The odor of marijuana is very distinct and can be used as a contributing factor in many, many cases where there are other factors that are going into the establishment of probable cause, and this would add to those factors and strengthen a police officer's case. So for those reasons, I have concerns about this bill, so I'm willing to take any questions.
Representative Welch.
Yes, thank you for taking my question. The scent of marijuana, is that having smoked it, or is it the weed itself? I have no conception of exactly what we're talking about here.
Well, I think that there's, oftentimes there's the odor of fresh marijuana and the odor of burnt marijuana. And as has been mentioned, it can at times smell, other things can smell the same, but when it's used as a contributing factor along with other factors, whether that's other evidence that can be seen or heard or intelligence that's known, this could be something that an officer can use to establish probable cause. And the way the bill is written, it doesn't appear that it would allow for that.
Representative Welch.
How does this apply to the dogs smelling the marijuana?
That is a good question, and I don't know how this bill would apply to that, but you are correct that a police canine does detect odors.
Representative Conley.
Thank you, and thank you for taking the question. We heard from the prime sponsor that the Supreme Court of the state has weighed in on this subject, indicating that the scent is not a means of determining probable cause. So would it stand to reason that all the things you've just described as far as the totality of a situation, you would need to build your probable cause on factors other than the scent?
So I'm not familiar with, I haven't read the Supreme Court decision, so I don't know that, but if that is the case, is that they've determined that it can't be used as the sole source, then then the way this bill is written, it doesn't appear that it would allow us to use that in building a totality case.
Representative Green.
Thank you, Mr. Chair. Thank you for taking my question. I don't know when the Supreme Court made a decision on this, but I know in the past I've gone out with Troop A on 95, and it was their means of catching drug traffickers going to Maine, of being able to smell this. Would this interrupt their work?
Well, I don't know what the circumstances were in the cases that you were a witness to, but the odor of the presence of marijuana is definitely a factor that a police officer can use to either establish probable cause or ask for consent or things like that. I'm not sure what the circumstances were in those cases, but if you were not allowed to use that to build a case, yes, that could hinder some of those cases.
Thank you.
Representative Roy, you're recognized.
Thank you, Mr. Chairman. Thank you for taking my question. As my colleague brought up the canine issue, is it true that canines are trained to detect a wide variety of narcotics? And when a canine alerts on a vehicle or a suitcase, there's no way for the handler to know what exactly the substances he's hit on until they've actually opened it. Is that right understanding correct?
Yeah, so I'm not a I'm not a canine handler, never have been, but yeah, that is my understanding, is that they can detect a wide array of substances depending on what they are trained on, and their indication, to my knowledge, you're not able to determine which substance they are indicating on.
Thank you.
Representative Lang?
Thank you, Mr. Chair. I just want to follow that thread. I guess I'm trying to understand from you, the canine, if I'm not mistaken, is the scent of a canine could be considered probable cause based on the fact that they're an expert, for lack of a better phrase, that's how the court deems them, that a hit on odor would be probable cause, but by this law, if this law were to pass, that would definitely put that into jeopardy. Do you think?
That could absolutely be a factor. There is, typically when a canine is used, there's been some reasonable suspicions established, and that's used as another factor. And if that, if marijuana, the odor of marijuana was taken out of that, depending on how the dog was trained, that may affect that.
Thank
Thank you.
you. The witness is excused.
Thank you.
If there are any members of the public who wish to testify that have not testified already, please submit a pink card. Seeing none, at this time we will now close the public hearing on House Bill 1400. The committee will be in recess to 2:15. To 2:15. 1598. At this time, we are now going to open the executive session on House Bill 1598. And at this time, the chair recognizes Representative Wallace to make a motion.
Thank you, Mr. Chairman. I move ought to pass House Bill 1598 and offer amendment number...
I second.
Representative Collins has been recognized to second the motion. Representative Wallace, wish to speak?
Yes, briefly. This rather comprehensive amendment ensures that the privacy of New Hampshire citizens that go to a cannabis store will have their identity protected. It's very comprehensive, provides the first $25 million of any net profit from this operation annually going to HHS. Further monies to public safety operations. Makes driving under the influence unlawful, provides for that all cannabis sold in the state shall be tested for purity and make sure that there's no contaminants, establishes banking processes should financial institutions not wish to accept monies from cannabis operations, and provides penalties for people that provide or make available cannabis to individuals under the age of 21.
See, Representative Marston. You have a parliamentary inquiry?
Yes. Are we talking about the bill itself or the amendment that was passed out?
It's the question that is open right now is the amendment has been offered. We have to adopt the amendment, then we can argue.
Okay, so we are
debate
talking about the
merits
amendment.
of the amendment. Yes.
Thank you.
At this time, yes,
The amendment number is 2022-0207H.
At this time, the matter will now be put to question. If you are in support of the motion to adopt amendment number 2022-0207H, please say yes. If you're opposed, please say nay. The clerk may call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
No.
Clerk votes yes. Representative Testerman. Representative Lang.
Yes.
Representative Pratt. Representative Marston.
Thank you. No, I'm sorry. Yes.
Representative Harriet Gathright. Representative Schultz.
Sorry, yes.
Representative Rung,
Yes.
Representative Bourdonnais,
Yes.
Representative Perez,
Yes.
Representative Newman,
Yes.
Representative Bolden,
Yes.
Representative Conley,
Yes.
Representative Klein Knight,
Yes.
Representative Bradley, Chairman Abbas,
The chair votes yes.
18 to 3.
By a vote of 18 to 3, the amendment is adopted. I presume Representative Wallace wishes to move to make a motion of ought to pass as amended.
So moved.
Is that seconded by? Seconded by.
Excuse me, I have another amendment.
The member's hasn't been recognized.
Did you recognize me?
I will not. We're in the middle of a motion of ought to pass as amended has already been made, and a member's been recognized for that motion, and I'm recognizing Representative Klein Knight to make. It's within the chair's discretion to not recognize someone to offer an amendment. You're not the only member of the committee that has that complaint, but it's not a free zone. Well, anyway, Representative Klein Knight, you wish to second the motion of ought to pass as amended?
Are we going to have discussion?
Now we will have discussion. Representative Tessman, do you wish to discuss the ought to pass as amended?
No, the ought to pass as amended is only part of the bill. And I have a second amendment that will enhance the bill. It won't cancel it, but it'll enhance it. So my problem is that you're using essentially a procedure and a mechanism to basically cancel this.
I understand the frustration you are expressing. My understanding, and anyone's free to correct me, is that there only can be one amendment adopted and recommended by the committee. We cannot actually adopt both. They could be merged, is a possibility, but we can't adopt one and then not adopt the other.
But we didn't even have the chance to merge them. We went straight to the approval of the overall bill.
And respectfully, it is within the discretion of the chair of the committee to recognize which amendment to be introduced. I understand that you may not agree with how that discretion was exercised. That message has been received and understood. I understand that. But in fairness to the other members of the committee, that has happened to other members have voiced that same frustration on other matters and other hearings. So
And I disagreed then, so never mind.
does anyone else wish to speak to the motion of ought to pass as amended? Representative Lang, you're recognized.
Mr. Chair, I just want to, I know we've had some conversations on this bill, and as a former police officer, one of the things that was most concerning to me is the ability for law enforcement to be able to enforce DUI, whether it's drug driving or drunk driving. And I appreciate the fact that this bill has money specifically set aside to allow for enhanced training of law enforcement officers to be able to enforce the laws and our driving rules of the road. So thank you for that inclusion in the amendment.
Representative Klein Knight, you're recognized.
Thank you, Chair. I just want to, for the record, state that this is a completely bipartisan piece of work. We met and worked very hard on compromising to be fair to everybody. We, on the House floor, passed a home cultivation bill, and this would not interfere with that bill at all. So it's a little bit of everything for the state. Hopefully that one also passes. But this is going to lower property taxes. It's going to fund public schools, and it's going to specifically go towards juvenile behavioral health in the state. So I would appreciate your support. Thank you.
Representative Perez?
Thank you. I just want to add that I'm really appreciate passing this bill. It's beyond time that we legalize cannabis in the state of New Hampshire. I believe that this is going to help us to bring some money, some equity to the state, and that's all I want to say. Thank you for passing this bill.
Representative Bolden, you recognized?
I have a question. This is an appropriate time to ask a question, right?
Are you making a parliamentary inquiry?
No, I have a question about the bill. Of you, I guess, or anyone in the committee who'd like to answer me.
You may present the question.
I'm just curious, what is the impact on of this bill on the entities that currently legally distribute medical cannabis in the state? Are they impacted by this? Would they be allowed to continue operating? Thank you.
And the answer is yes, they will be allowed to continue to operate, and they will not have any impact. And there was a conscious effort when this was drafted to not have any impact on the medical industry, which is separate. And in fairness, those are enterprises or businesses already operating. So we made sure not to do that. At least that was not the intent for us to do that. You recognize again, Representative Bolden?
I'm sorry. I think after asking that, I realized what my question really was how does this impact the alternative treatment centers that provide services currently?
I believe that my same answer, that they would not be impacted by this. And that was certainly not the intent to have any impact on any existing business that's currently in operation. Representative Conley?
Thank you, Mr. Chairman. This House has tried for many years and many a term to get cannabis legalization through, and the outcome has been the same every time. This represents a new approach, one that has not been tried, and one that hopefully will have a different outcome. So looking forward to voting for this.
This time, the matter will now be put to question. If you're in support of the motion of ought to pass as amended, please say yay. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt.
Yes.
Representative Rhodes.
Yes.
Representative Green.
No.
Clerk votes yes. Representative Testament.
No.
Representative Lang.
Yes.
Representative Pratt.
No.
Representative Marston.
Yes.
Representative Harriet Gathright. No. Representative Schultz.
No.
Representative Rung.
Yes.
Representative Bourdonnais.
Yes.
Representative Perez.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley. Chairman Abbas.
The chair votes yes.
Mr. Chair, I wanted to make sure that yes is marked as my vote, please. I think I said no in error.
You did.
It may be changed. The vote has not been finalized.
With a vote of 18 to 4, the bill is adopted.
It can't be 18-4.
Can't be that, unless we got a new person.
Hang on.
We'll get to the bottom of this.
I stand corrected again, 17-4.
By a vote of 17 yeas, 4 nays, the ought to pass as amended. The motion passes. Will there be a majority report? You want me to write it? I'll write it. Will there be a minority report? Representative Tessman will do the minority report. At this time, we will now close the executive session on House Bill 1598. At this time, we now open the public hearing on House Bill 1266 relative to restrictions on enforcement of federal immigration laws.
The committee calls Representative Tony Piemonte.
Thank you, Mr. Chair and committee members. My name is Representative Tony Piemonte. I represent District 4, Sandown, Chester, and Auburn. Thank you for allowing me to introduce House Bill 1266. House Bill 1266 is an act relative to restrictions on enforcement of federal immigration laws. I'm not against immigration. I'm against illegal immigration. That does not abide by the U.S. and New Hampshire constitutions. My father immigrated to the United States from Italy, but he did it the legal way, like so many others. It is the undocumented illegal immigration that is jeopardizing our safety and draining resources that should go to immigrants who legally come to the United States. All nations have borders. We can't sustain open floodgates. This bill, House Bill 1266, will ensure that New Hampshire adheres to all federal immigration laws at the local, state, and federal level. I will ask for a not to pass motion for House Bill 1266. I thank you, and I will not be taking any questions.
The witness is excused.
The committee calls Eva Castillo.
Good afternoon. Thank you for listening to my testimony today. My name is Eva Castillo. I live in Manchester. I have been in this country legally also for 41 years, but I happen to work with immigration. I'm an immigrant advocate. And nobody chooses to come to this country illegally. The system precludes them from being here legally. I cannot tell you the thousands of dollars that I spent to adjust my status, even though I was married to a U.S. citizen. So this is just a side. I'm here to speak against this bill. Part of my job is to build relationships with the police. From all Latin American countries and for the most part African countries, our police officers are crooked, they're mean, they're corrupted, and they're criminals. And that's what we grow weary and scared of them in our own countries. I remember my mom always told me, stay away from the cops. Don't you ever ask for help from them, because if the robber doesn't rob you, the cop will. And this is what our reality is. When we come to this country, we fear the police because that's all we've learned. I was a victim of a sex crime in college, and I knew who had done it, and I was so afraid of the police that I just swallowed it, and I lived with it because I was more fearful of the police than I was of the rapist. When I came to New Hampshire, I started building relationships with my department in Manchester. We first approached them concerned about issues of profiling, And I built a relationship with them, and I learned to see that what I had learned at home doesn't apply here. That our police departments are an honorable profession, and that they are here to help us and to serve us. So I have worked with them for many, many years. I still go all over the place. We have built all kinds of relationships. This bill would undo all those 20-some years of work that we have done to foster trust in our police departments. This bill is not going to help anything. It's not needed. This bill is going to preclude people from trusting the police to come and report crimes. This bill is going to make all our communities unsafe. This bill is going to make our police departments prone to civil lawsuits. There is no reason to have a bill. First of all, we do not have the resources to do the feds' jobs. They have plenty of money and they do their own thing. So our police departments should not use the resources that they need to keep our community safe, persecuting people that are here undocumented. There's already rules in the books to go after those people that commit crimes that happen to be undocumented immigrants. So this is only just going to help people do profiling. So I just want you to think about it, and I urge you to vote this ITL.
Representative Klein-Knight.
Thank you, Chairman. Thank you, Ms. Castillo, for your testimony today. It was very brave and coming forward. I appreciate that. Do undocumented people pay taxes?
Undocumented people pay taxes. They do not have the right to get a social security number and the right to work, but if you do not work in this country, you do not eat. So the IRS has a tax ID number, and that's what they use to claim their taxes, and they do pay their taxes.
Representative Bolden.
Thank you for taking my question. You spoke about the possibility that this legislation would exacerbate relationships between the public and police. Is it the case, to your knowledge, that this would possibly discourage victims of sex trafficking from going to police for fear of being caught in legal troubles?
Of course. And you know, it has happened before when we did not have those open and trusting relationships where people did not want to go to the police. And it's still, you know, a work in progress. I have to work on the immigrant communities to trust the police, but many times they're safer. They feel safer if they tell me, and I'll go with them to the police departments. But it's definitely going to deter people from reporting crime.
Follow-up.
Thank you for allowing a follow-up. So that makes me wonder if a police department has a policy that if someone's brought to this country illegally and they're being victimized, being sex trafficked, if a police department has a policy that they will not prosecute that person for being in the country illegally because they came here through sex trafficking, would this bill require the police department to abandon that policy, require the police department to prosecute a victim of sex trafficking?
There are special visas for victims of sex trafficking, so I don't think this would affect that person. But say somebody happens to be driving without a license and they get stopped for an infraction, then the police department will be mandated to call the police, to call ICE on somebody that just happens to be, or if they just happen to encounter somebody walking on the street that fits the description of whatever, somebody that they're looking for, and they decide, they check their documentation and find out they're undocumented, then those people would be affected. I don't think it would affect victims of domestic violence per se, because there are special visas for them.
Representative Schultz.
Thank you, Mr. Chair. I have two questions, if that's okay.
Just one at a time. I will recognize you for a follow-up.
Okay, thank you. First, regarding our current U.S. immigration laws, are there limits to the amount of visas that are available? And do you feel, well, this is actually part of the same first question, that New Hampshire's businesses need more visas and are, available visas?
Oh, yes, there's limits of all kinds of visas, the work visas, and there's different visa categories, and there's, the main way to immigrate to this country is through family relations, but the countries that send the most people, Mexico, Philippines, they only qualify for, I haven't done this, but for like 12,000 visas a year. So there's 19 million people waiting for those. So it is really hard to come into a visa. In fact, 2 days ago, I got an email from a company up north that is desperate looking for workers and asked me, please help me find people that are willing to relocate to the North Country, and I'll employ them because we are really lacking employees. We cannot find somebody to help us.
Representative Schultz, you're recognized for a follow-up.
Thank you. This is actually a separate question. And this is looking at information that was handed out before we started talking about this bill, so you haven't heard the testimony or probably seen the information that we were handed. But a national organization is here and presented information about violent criminals that are undocumented. Is there a higher percentage of violent criminals in the undocumented population?
No, and if that national organization happens to be fair, it is an organization that has been cataloged by the Southern Poverty Law Center as a hate organization, and that's not true. In fact, undocumented immigrants commit far lesser crimes than native born or people that have green cards, because they know what's at stake also, They come here to work hard, and that's all they want to do, make life better for their family, just like a lot of your ancestors did when they first came to this country. And the difference is that probably prior to 1924, there was no visa, so all that people needed to do was show up and be counted. My own family comes from Italy, but they just happened to stay in Latin America. But if they had come here, that would have been the case too.
Thank you.
Representative Testament.
Thank you. Thank you for taking my question. Let me see if I understand you. You said something earlier, and I mulled it over. You said something to the effect of anybody who wants to should be able to come to this country and work and have documents and so on. There should be no limits to the people who come.
Is there a question?
I mean, did you say that?
No, that's not what I said at all.
Thank you for your testimony. The witness is excused.
Thank you. God bless you.
We now call Bruno De Brito.
Good afternoon, Mr. Chair. Good afternoon, members of the committee. My name is Bruno De Brito, and I am president of the New Hampshire Brazilian Council, and I am also an immigration attorney. I am here today to speak about against this legislation. Contrary to what many believe, immigration is not a criminal matter. It's a civil offense. Also, anybody that came here before 1924 came here without a visa. So the same concept that these individuals, they are being called illegals today. Not necessarily that they were illegal before, but simply they are being made illegal today. But unfortunately, people cannot be considered illegal to be illegal. Only drugs, contraband can be illegal. No person shall be deemed illegal. we keep talking about, like illegal immigrants. It is a, like an extreme bad term to use towards a human being. We should refer as, simply as, people and not illegals. Also, as my colleague Eva Castillo, have mentioned before, we have worked with law enforcement for many, many years to establish a relationship between law enforcement and the community, because crimes do happen in the community, and not necessarily they are committed by immigrants. They are committed by everybody, and the rate of crime committed by immigrants are not necessarily related to the increase of immigrants who are undocumented coming to the community. There is a study that I tried actually to pull up that actually has been done in the Nashua metro area that that really breaks this link about the premises that the increase of crimes are related to the increase of immigrants coming to the community. Unfortunately, I wasn't able to to find that when I was called, but there is a study, and I can pull it up, and I'll be more than happy to share with you guys. And as she said, like we have established the relationships, like with police officers, chiefs of police, the Attorney General's office, to work again to create, like a bridge between the community and law enforcement and help them to solve crimes. And like, and unfortunately, these violent crimes, as like as I mentioned, there is a memo by a sheriff from Massachusetts that only states one isolated case that tries to broaden what really happens in the community. So immigrants, they just come here for the same reasons as like your ancestors came here. They come here to seek a better life. They come here so that kids can get a better education, so one day they can become professionals and fulfill like their dreams. And they don't come here to, oh yeah, like we're gonna go to the United States so we can start robbing CVS. So that's that's not that. So like one day these kids they're fruit of the immigrants that are coming here that many of you label as illegals. They're gonna be sitting where you are right now. So give them a chance and stop labeling them as illegals. They're people. Thank you. I'm open to any questions.
Representative Lang, you recognized?
Thank you, sir. Thank you, Mr. Chair. Thank you for taking my question. So I'm going to try and back up a little bit in the conversation, a little higher view of this. So we're talking about policies and establishing policies. My question to you is it good public policy that the state would allow a political subdivision under it to create a policy to ignore law and not enforce law? Is that good public policy?
So it's not. So it's not that they are not enforcing law, and that's the beauty of it. So what we like have like with the chiefs of police, like they state, is that yes, you are going to enforce the law if there is a warrant, like like on your name. If you are like an immigrant, the police like pull you over. Yes, you are going to be detained. You are going to be placed in removal proceedings. But if you are here and you get pulled over because like you didn't put your blinker on and you get pulled over, the police officer comes to you, asks you to present your license, and you're unable to produce your driver's license. So and you're only here to feed your family, to get like a better life. You don't have any crimes, you don't have anything else. So in that case, yes, so the person will be sent to to the court, pay the fines that they have to pay with the state, but they're not going to be asked to they're not going to call ICE, which is Immigration Customs Enforcement, which is a different jurisdiction, because the job of the local police is to enforce local laws and not federal laws. So we are trying to keep this separate. That's all we're doing.
Follow-up, Mr. Chair?
Recognized for a follow-up.
Thank you. So again, I'm trying to get, because this doesn't actually talk about an individual, right? This is talking about, this bill as it exists is about the state agent, about political subdivisions, towns, cities, police departments, establishing policies that says we won't enforce law. And my question is that good public policy that we allow those organizations to establish an overall policy that would govern itself, to say that we're not going to enforce a law that was lawfully enacted?
No, it is indeed a good public policy, because as I mentioned before, if it is someone that hasn't committed a crime, okay, so that it is not the job of the state to enforce federal laws, and actually would be like deemed unconstitutional, as we have seen like in the case U.S. v. Arizona in 2012. Okay, so it is the job of the state to enforce state laws. It is the job of the town and cities to enforce local laws, and it is the job of the federal government to enforce federal laws. And we should all keep them separately. The state should not be burdened, because we don't have the money to be enforcing like federal law, and we don't get any like federal money to enforce federal law. So yes, it is a good public policy, because these are families in the communities. A lot of families were torn apart. So imagine like you're going like out to to your work, and and when it's like lunchtime, you get a call like saying that your wife was detained, and like you're not gonna see your wife for probably like another year, unless you're able to travel to another state like in detention, and like your wife is placed in removal proceedings. So it's something that you don't expect. And these individuals every day, these are families. Again, the good people, yeah, let's keep them here. Like criminals, yes, the police officers, they do enforce the warrant. That's part of the agreement.
Representative Schultz.
Thank you, Mr. Chair. The sponsor of this bill didn't take questions, but did mention the concept of sanctuaries, like sanctuary churches, sanctuary congregations, sanctuary cities. In what way has the sanctuary aspect that I guess this bill is trying to address been a benefit to our society?
So honestly, I see it as like on like I see it differently. Like how can like this harm actually? To this day, we have no history whatsoever from like a like an agency or anybody trying to interfere with ICE and customs enforcement. We don't have any history in the state to this date. So that's how I see it. You're welcome.
Representative Perez.
Thank you for taking my question. Can you explain to me what the difference is when someone calls someone illegal alien and undocumented person?
Yes, so, like an illegal alien, unfortunately, is used, by, like a certain group of individuals, to look down, like upon another. And undocumented, like immigrants is more, like within, the boundaries, like of the law, because the law, like requires that, someone, carries, like a document. And then if that person doesn't carry a document, they are undocumented.
Follow up?
You recognize for a follow-up.
Thank you. Do you believe that we have to educate the people in our communities to, when they making a document, to make sure they don't use the illegal alien word in the documents instead using the word undocumented person.
The member would just suspend. We might try to keep the questions germane to the bill. The prior question I thought was acceptable, but.
It is.
So,
But would the member wish to ask a different question, not as germane to the bill?
Nope.
Mr. Chair, where am I answering?
The question was deemed out of order. The chair ruled it out of order.
Okay,
If I can just, the chair would inquire one question, and thank you for your testimony and taking my question.
absolutely.
If a person enters the country lawfully under our current immigration laws, what is the, I guess, objection to then enforcing our immigration laws while the person's in the country?
So in regarding to placing them in removal proceedings? I'm sorry, I don't understand your question.
I'll rephrase it. If a person enters the United States of America legally,
Okay.
under our current immigration laws, if that person is now in our country legally, what is the objection to actually continuing to enforce the immigration laws, the same laws that allow them to enter the country?
So I mean, yeah, I'm honestly having a little bit difficulty understanding. I'm sorry, but essentially, if the person enters, the country, like with a visa or like with, like a green card, the same way that the law is enforced for documented individuals, it is enforced against undocumented individuals. And even if you come here with a visa, you have to follow certain requirements. Typically, like a non-immigrant visa, when you come to this country, you have a certain amount of period here in this country, and you're not allowed to get a green card, through the immigrant visa, okay? Unless, certain, exceptional circumstances, like happen, and then you're able to adjust your status, okay? But that's a different topic. But if you violate, the conditions, like of your visa, then you may be deemed deportable. So so pretty much it goes back to essentially you become undocumented, and the majority of the individuals who are here undocumented, they did come with a visa.
Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. When I look at this law, my question is about how it potentially could be implemented. And the question is, if you have someone who is born here and for some reason is a legal citizen and may have an accent or an appearance that someone may think that they could be illegal or not illegal, or anybody really, how does that person then prove it if in fact they were born here? Would you have to ask everybody if you couldn't have any discretion as an agency they would then have to say you have to check every time you stop someone, you have to check and make sure that
Representative Newman.
Thank you.
Yeah, so yeah, and that's like another thing. Yeah, so we wouldn't have to start asking people for citizenship like statuses. And there are a lot of like US citizens, believe it or not, they're unable to prove that they are like US citizens. I have come across like a few in the past like a couple of years, and actually they ended up like in removal proceedings, and and even veterans, believe it or not, even veterans. And and that's the issue like with one of the issues like with this bill. And coming here documented or like undocumented, there are certain very slim possibilities for these individuals to actually become, like legalized. And actually, there's a report that, that came out recently, that shared, like what are the most immigrant populations in each state. And, and guess what is the biggest, most populous immigrant population in New Hampshire? Undocumented and undocumented and documented. Guess which one it is? Yes, you guessed it correctly. Canadians. And I bet some of you might have thought Mexicans, but it's actually Canadians. Any other questions?
Representative Roy, you're recognized for a question.
Thank you, Mr. Chair. Thank you for taking my question. I'm over here, front and center. Hello.
Oh, sorry.
There you go. That's okay. It seems like we're getting a little bit far from the law itself. My question to you is, how does somebody get an ICE detainer put on them?
So pretty much, so the only way is if ICE comes, in contact with them. Okay, so either if, they give, themselves up, like at the border, which, like is happening a lot. So Customs and Border Patrol, they process these individuals. They are handled over to Immigration and Customs Enforcement, ICE. And ICE is the agency responsible to begin the removal proceedings of these individuals. So that's one way. Another way is if someone, like reports, like an individual, and the individual is actually interested, like of ICE. So then ICE, comes in contact, like with them, and then may place them in removal proceedings, or in some cases in order of supervision. And there are other avenues that like ICE uses depending on the person. So, or if someone documented or undocumented, they commit a serious crime, and pretty much, and this crime is deportable, then ICE comes in contact, like with them and place them in removal proceedings.
Representative Roy, you recognized for a follow-up.
Thank you. So is it your position that it's not okay or not good policy for the local law enforcement to call ICE and inquire about that detainer if, in your own words, some of the people may have committed serious crimes?
So if they have committed certain, serious crimes, ICE will definitely, there is no question, like about that. That's, like what I addressed with the representative, I'm sorry, there's no name. So that's what I addressed, like with, like with him. So if they committed, like a serious crime, like especially, like domestic violence, for example. So, like ICE immediately, like if they're found, guilty, like ICE, like definitely, picks them up and places them in removal proceedings. There is no question, like about that. It happens 100% of the time.
Thank you.
You're welcome.
Representative Klein-Knight.
Thank you, Chairman, and thank you for taking my question, Bruno. If this were to pass, would it increase racial profiling?
Yeah, absolutely. You wouldn't just do that, but you would, deter, the work that, like we've been doing, especially with, like Eva, like for years and years, to build relationships, like with law enforcement and prevent, like people from actually, like reporting crimes. As a matter of fact, one of the chiefs that we have a relationship with, he stated that he was investigated, like a crime that happened in a neighborhood in his area, and they went, to knock on the door of, the family, like, and everybody just pretended that, they were not home because they were afraid that, that the police was there to actually, like arrest them and place them in removal proceedings.
Thank you. The witness is excused.
Thank you.
We now call Grace
I'm not sure.
Kink.
Representative Newman, you have a parliamentary inquiry?
No, I don't have problem. I just wasn't sure whether we're limited to one question. You have one round. I just wonder where we are in that process. Thank you.
I have not expressed any limitation. The only time there's ever a limitation on the questions is more due to time constraints than anything else.
Thank you for the clarification.
And the committee calls Grace Kink. Okay, thank you.
Thank you. So good afternoon, everybody. Thank you so much. I'm very glad to be here to be able to share my story with you. Thank you for taking my testimony. My name is Grace Kindeke. I'm the program coordinator with the American Friends Service Committee. I'm also a longtime New Hampshire native, I guess. I grew up here. I've been here since 1989. So I just wanted to first share a small story. I grew up in Manchester. It's my hometown. Like I said, I've been here since I was 2 years old. And when I came to this country, I went to school here, went to Webster Elementary. And when I was in the first or second grade, I was walking on Hanover Street. No, actually, I apologize. I was shopping with my aunties.
Excuse me, the witness will suspend. We do have to have members of the public stand on the other side of the table. I do apologize for interrupting. Yes. Thank you. I do apologize. And you may continue.
Sure, thank you. So I will just say again, my name is Grace Kindeke. I'm here in opposition to HB 1266. And I want to tell you a story about when I was in first or second grade. I grew up in Manchester. I've been in this country since 1989. And I was shopping with my aunties up where Ames used to be on Hanover Street. And I lost them in the store. I couldn't find them. And I was really, really scared. So in my child mind, the best thing I thought I could do was to leave the store, walk across the parking lot, get onto Hanover Street, and somehow make my way home by following the lights of downtown that I could see. So I was walking and walking and walking and walking, and I started to cry because I was dark and I was scared and I didn't know where my family was. A really, really nice couple who was taking an evening stroll heard me, found me, asked me what was wrong, took me to a convenience store. And while I was there and they were giving me some candy and everyone was being really nice to me, a Manchester police officer came over, picked me up, and took me to the station. When I went over there, after a little while where all the officers were treating me very kindly, asking me where I was from and what my name was, they were finally able to find my aunts who were able to come over and get me. Now, this is a pretty typical story, I'm sure, for those of you who have kids, either your own or in your family. But what's notable about this particular story is that at the time I was undocumented. I came into this country in 1989 on a visa, so I came here, as you say, technically legally. I outstayed that visa, but at the time I did not know that because I was a child. I was undocumented, my mother was undocumented, and many members of my family were undocumented. If a bill like this passes, or had passed back then, it would have meant that when I was picked up by the police, they would have had to report us to immigration, and then we would have been picked up and I would not be standing here with you today. I would not have gone to school, would not have graduated, bought a home, married my husband, and settled here in New Hampshire, which is my home. So, for those who don't know, this bill does not do what it says that it claims that it does. I know that as lawmakers, one of the things that you have to weigh the most is intent over impact. And the impact of this bill is to undermine what municipalities have, many municipalities, including Manchester, in fact, Manchester was the vanguard, have created in order to ensure that all members of our communities feel safe and feel that they can rely and trust and go to the systems of support and safety and care that we have set up. This bill, in thinking about the impact that it has on municipalities, undermines local control. It tells municipalities, it punishes a problem that is not in fact happening. Our law enforcement have done an incredible job attempting to connect with the community, respond to the community, to be able to serve the communities that they come from. And a bill like this undermines that. It undermines those relationships, and it goes against the very values that we have as a state. This is a state that values being able to look one another in the eye, to be able to know who your neighbors are, to be able to set forth the rules and regulations that make the most sense for the communities that we come from. There is no need for a bill like this. And in fact, the intent, as the bill sponsor, the gentleman representing the bill, clearly spoke of, was about deterring illegal immigration, illegal immigrants. Immigration is a complex issue. This bill does not do that. What it does is it otherizes an entire thousands of New Hampshire residents, including people like myself, folks who have already sat here, people you see very often, and many more that you don't see in these hallowed halls, who are working, living, paying into the state, who are acting as our essential workers, who are keeping this country, this state running, especially now during this pandemic. And it is egregious and disappointing to sit here and listen to something that could pass that would undermine all of those efforts, that energy and that ability for our municipalities to regulate, support, and care for its citizens. Thank you. I'm happy to take questions.
Representative Roy, you're recognized.
Thank you. Thank you for taking my question. Is it your position then that no one should be deported from the United States who's entered here without the proper documentation?
That is an interesting take on what I have just said. That is not,
it wasn't a take, it was a
so,
question.
like I said, that is an interesting take on what I've just said. That is not at all what I'm saying. So what I am speaking to is the fact that immigration is a very complex system. And the problems that are found in immigration are very complex. And the reality is that this country deports millions of people every year. And the majority of those people shouldn't have been deported in the first place. And if we really want to solve those issues, then the real question, the question that we should be asking is, why are people who shouldn't be getting deported getting deported?
Representative Newman?
You mentioned the impact of this bill. Could one of the potential impacts be that regular United States citizens who were born here or normalized here could be profiled and then would have to prove their citizenship status and maybe have to get somebody to get their birth certificate out or whatever it is? Because as far as I know, that's all I have that proves my citizenship.
Thank you for that question. So I think that's very interesting because it definitely does, a bill like this absolutely does create a situation where profiling ends up happening. Because what you're saying is that cities and municipalities who have recognized, who have worked with their communities and their citizens to say, you know, when these things happen, when civil law enforcement cooperates with immigration enforcement in ways that they don't need to, is not unconstitutional, nor is it illegal. They choose not to go into, what is it called? What is the word I'm looking for? I speak multiple languages, so I think in multiple languages. When they go into voluntary agreements, they're saying we do not want to go into voluntary agreements because we know we've done the work to understand, based on what we have researched and what we've talked with our citizens, that when these things happen, profiling happens. And when profiling happens, no one is safe. And the reality is that many immigrants live in mixed status families. My husband was born here. Sometimes, you know, if he has like a deep tan, he doesn't look what you would think of as American. Sometimes in the dead of winter, he does. So for many of us who come from mixed status families, we're setting up a situation where a bill like this makes it so that there is a sense of instability and not being safe. Who knows if someone in my family who will be profiled? Who knows that it matters if I have to carry my papers with me every time that I go into my car, other than my driver's license. So the implications of this bill is very, very disturbing. Thank you.
Thank you for your testimony. The chair may inquire with a question, and thank you for taking my question. Can you provide one example where a person should not have been deported but was?
So I'm not an immigration lawyer. What I can say is I can provide an example of a community member whose identity I will keep very, very private, who is fighting for his life. He's fighting to stay here. He comes from a country where he is absolutely would be killed the minute he set foot back in his home country. He is fighting to ensure not only that he survives here, but that the family back home that he has left behind, the young children and his wife, who are back home will be able to move freely and not be constantly terrorized as they have been since he set foot in this country seeking asylum 2 years ago. Now, this man came with a cohort of other African immigrants from the same country or nearby, and almost all of them were able to enter the country after a period of detention or were able to adjust their statuses to receive asylum. He was the only one. And the reason for that, the difference between him and them, was that he didn't know anybody in this country. So when we're talking about a complex immigration system, that we're asking the question, why do people who shouldn't get deported? It's because of reasons like this. Because of small, specific, very granular rules that impact people in unbelievable ways.
Thank you for answering my question. If I can ask for the follow-up. So the immigration, I mean, that's a federal law issue that's going on. I suppose my question is if we were ever to have any type of immigration reform, how would we do that if we don't enforce the immigration laws, whether the current laws or whatever we were to reform the federal law too?
So there's not enough time for me to give a history lesson, but I think one thing that's important to note is that immigration law has changed drastically in the last 2 to 3 decades. So I'm 34 years old, almost 35 years old, and the way that immigration law was set up when I was 2 compared to the now being in my mid-30s is very different. And so what we have is that we have set up our laws exponentially, administration after administration, to become even more punitive, to catch more people, to criminalize them, to label them as criminals, to find reasons to put them in detention, deportation, and close them out from being able to come into this country. So we have already done that. We have set up a system that is focused almost entirely on punishment, detention, and deportation, instead of what the system was originally set up to do, which is to serve, which is to understand why people are coming, and then to serve and to figure out what is the best way to process them while maintaining their humanity. So again, the real question that we should be asking with the question that you've asked, Chairman, is that how can we build a system that uplifts, that not only lives up to the values that we have as a country, but serves the original values of the ways that it was intended when it was first built? And also noting the fact, as my colleague Bruno said, before a certain point, we didn't have immigration system the way that we do now. And certainly if we designed it to be one way, we can design it to be another.
Thank you. The witness is excused.
Thank you.
Committee now calls Maggie Fogarty.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Maggie Fogarty. I'm the New Hampshire Program Director for the American Friends Service Committee, and I'm here today to speak on behalf of the New Hampshire Immigrant Rights Network, which is a statewide coalition of individuals, organizations, faith leaders, attorneys, working together to advocate for humane immigration policies. Certainly at the federal level, which is where our immigration policies primarily are, but also at the state and municipal level, because policies are made there which impact immigrant communities. And I have testimony to submit to you. In the interest of time, I will just lift up a few key points, and then I'm happy to take any questions. We are in strong opposition to HB 1266. We believe this bill is anathema to New Hampshire's principles of equity and justice. It is unnecessary, confusing, and vague. If passed, this bill will cause widespread confusion and result in the violation of New Hampshire residents' constitutional and civil rights, and will expose local and state officials to liability. It also interferes with the independence of our judiciary. As has been discussed, immigration jurisprudence is carried out exclusively within the federal domain, mostly within the administrative civil process. New Hampshire has a full complement of federal law enforcement agencies operating within our borders, including immigration enforcement divisions. There is simply no need for state laws or resources to be diverted toward immigration enforcement or to targeting immigrant communities. It is clear that the state and local government authorities already have obligations to comply with state and federal laws. So this bill does nothing to clarify that. The vagueness of this bill leaves it to government officials to figure out how such a law would apply in actuality. Fear and anxiety about the presence of immigrants in our communities has been fanned by legislation like this and contributes to a rise in hate and injustice. National anti-immigrant organizations such as the Federation for American Immigration Reform, FAIR, have been a significant factor in crafting anti-immigrant laws throughout the U.S. They were clearly involved in a very similar bill last year, HB 266, and quite possibly involved in the creation of this very similar one. Our legislature should not be influenced by anti-immigrant sentiments. We should be enacting laws that protect the welfare of all of our residents. HB 1266 is particularly pernicious because it's designed to raise fear and confusion within immigrant communities. Its vagueness will contribute to uneasiness, as it's unknown how it would affect all interactions between people perceived to be immigrants and government officials, government programs, community organizations. Immigrant families may refrain from interactions with law enforcement or participation in programs and activities to which they are fully entitled for fear of how this law is being interpreted. If enacted, HB 1266 would trigger the risk of increased racial and ethnic profiling, animosity, and distrust of those perceived to be immigrants. And it doesn't take a lot of imagination to know what kind of data is used to perceive someone to be an immigrant. People of color will be targeted by this bill. So for all of these reasons, we urge you to find this bill inexpedient to legislate. As a resident of Dover, a community with a wonderful immigrant community, within that community, our local police have enacted a practice of not seeking to determine the immigration status of someone they encounter in their normal course of business, and it has made our community stronger and more welcoming. Thank you very much.
Representative Roy?
Thank you. Thank you for taking my question. I agree with you. I think our country is made richer for our immigration. But I am confused because we also made richer because we're a nation of laws. This bill, as I read it, I can't see where it directs law enforcement to do anything other than not thwart federal immigration. So I'm going to say something. I want you to tell me if I'm incorrect. Right now, in a sanctuary city, if someone is arrested and when they're put into the system, as everybody is, no matter their immigration status, if there's an ICE detainer, it pops up ICE detainer. This law would say that they do have to notify ICE that they have that person in custody. It doesn't say that they have to go out and start asking immigration status questions or stopping people. So is that correct, or am I reading it wrong?
I think you're reading it generously. I think that the language in this bill is so vague and inclusive that not acting as immigration enforcement agents could be perceived as not cooperating with federal immigration laws. So the issue pertaining to detainers, Attorney Klementowicz, who's coming after Attorney DeBrito, spoke to the fact that those are already acknowledged among law enforcement officers. They have a duty of cooperation. But this bill is written in such a way to capture all sorts of other behaviors that would easily be interpreted to be required.
Thank you.
Representative Klein-Knight?
Thank you, Chair. This is more of a point of order. Section...
You're recognized for your point of order.
Thank you. Section 805 on public order. Maureen Maloney's testimony needs to be stricken from the record. It's inappropriate, and it just cites that all immigrants are criminal aliens. And I urge that it be removed.
Well, may you please read the rule again?
Section 805, Chapter 74 of Public Order, number 4. It is within the discretion.
I can read the rule.
Okay.
Apparently some other members would like you to read it out loud.
Also, thank you for giving me the book.
Don't make me regret it. Can you mind repeating the rule?
Yeah.
I'm glad I didn't give you the gavel.
Yeah. Section 805, maintaining order in legislative bodies. Oh, you want me to?
You may read the rule
Okay.
aloud.
It is within the discretionary capacity of a presiding officer of a legislative body to insist upon the orderly recognition of speakers and to make quick judgments as to what method to use to maintain order at emotionally charged meetings.
So your point of order is that the written testimony submitted by a member of the public is not violates Rule 805.
Well, it's inappropriate, and it's within our power to strike it as.
So you're asking the chair to strike. I'm not going to strike any of the written testimony submitted by any members of the public. I'll leave it to and trust the members of the committee to evaluate and take into consideration that written testimony. I also have not read the written testimony yet, so I would have to do that in order to, I'm not going to make that ruling right now.
I have a question of the chair.
That's the ruling of the chair. I will, but while we're sitting here, I will take a look at the testimony. You don't need to get up. There's a copy right here. My clerk sitting to my left just pointed it out to me.
Mr. Chairman, I was...
Senator Roy, you have a parliamentary inquiry?
No, I was wondering how I could get one of those books. You're handing them out. I mean.
Just to clarify, this is borrowing.
Actually, I will take up in the offer for that written testimony. You can pass it along. Let me read the first one, and then we'll worry about the second one. But we want to keep the members of the public while we talk amongst ourselves. Let's keep the hearing moving.
Mr. Chairman, is this the appropriate time for this?
No, that's why I want to move on.
Thank you.
Seeing no further hands raised, I want to thank the witness for her testimony.
Thank you.
The committee calls Henry Klemenowitz. Hopefully I didn't butcher your name, sir.
Thank you, Mr. Chairman and members of the committee. My name is Henry Klementowicz. I'm a senior staff attorney at the American Civil Liberties Union of New Hampshire. I'm here today testifying in lieu of our legal director, Gilles Bissonnette, who wishes that he could be here with you today and sends his regrets. He had emailed you some written remarks that I plan on expounding upon. So I want to start with let me start by saying that we're testifying in opposition to this bill. And then move on to what I think are a few drafting errors with the bill. So the first of which is that this bill would prohibit judicial officers from acting in a way which restrict or discourage the enforcement of federal immigration laws. And I think this branch of government telling a judicial officer what they can or can't do raises serious separation of powers concerns. In addition, this bill, by acting upon any appointed or elected official, could be construed as prohibiting members of this body from advocating in any particular way in violation of the state constitution's speech and debate clause. If this bill were to become law, it could arguably prohibit a future legislature from moving to repeal this bill because they would be elected officials adopting a policy to restrict or discourage the enforcement of federal immigration laws. And obviously this legislature can't bind future legislatures, and I think it would be a violation of the speech and debate clause for it to criminalize or make illegal remarks of members of this body or the other body. Next, I think HB 1266 could require municipalities to violate the 4th and 14th Amendments of the U.S. Constitution, as well as Part 1, Article 19 of the New Hampshire Constitution, by potentially requiring police departments to seize people without probable cause. So an ICE detainer is different from a typical arrest warrant in that it's not necessarily supported by a probable cause, nor is it reviewed and issued by a neutral and detached magistrate. So an arrest warrant in New Hampshire has to be issued by a judge, a member of the judicial branch, whereas an ICE detainer does not. And so courts across the country have found that police departments seizing people on the basis of immigration detainers issued by ICE have violated similar state constitutional provisions because they're effectively making an arrest without probable cause or a neutral and detached magistrate's arrest warrant. And I direct you to footnote 4 in our written remarks. I'd also say, in response to a question from Representative Lang to another witness as to whether it would be good policy to permit a subdivision of the state to enact its own rules in terms of how it wants to enforce the laws, I would say to you that currently police departments and prosecutors' offices exercise prosecutorial discretion in all manner of ways and for all manner of reasons. So, for example, a police officer may see someone jaywalking. That's a violation of the law, but they may decide to issue someone a written warning or a verbal warning rather than a citation or an arrest. And that's the type of discretion that's best left to local control. And so I'd refer you to a case that we had where we represented a man who was seized by the Exeter Police Department in, I think, unusual circumstances. So he was an undocumented person who was working at a convenience store when a woman in the convenience store had reported that she had been unwantedly kissed. And the police responded, and they figure out who the suspect is, and they go to try to talk to that person, and he doesn't speak English. And so our client, who was not the suspect but also worked at the store, offers to translate for the Exeter Police Department. And he does that and, in fact, enables the Exeter Police Department to assist their investigation. After that, the Exeter Police Department asks him what his immigration status is, and he answers truthfully that he's out of status and is arrested. For my money, that's a pretty good example of how instituting a blanket policy that every person who comes into contact with the police has to answer questions about their immigration status could discourage witnesses to crimes, victims of crime, from cooperating with the police and could make them feel less safe. And I would put to this committee that whether and how to enforce those immigration laws that are really primarily the subject of the federal domain is best left to the locality that knows those issues the best. I also wanted to answer a couple questions that the chair had asked of a prior speaker. Mr. Chairman, one of the questions you had asked was, how would a lawful immigrant be negatively impacted by this bill if passed? I think in addition,
With respect to your testimony, I don't believe I asked, the chair does not recall asking that question.
I
But you may speak as
I may be
hypothetical, but just for the record.
paraphrasing, I thought the question was, how could a person who was lawfully in this country, how could they be negatively impacted by the enforcement of federal immigration laws? But
Direct the question to you if it would assist the witness. I asked that what is the concern with having a system where a person lawfully enters the United States of America, but then what is the opposition or objection to then enforcing those same laws that allow them to come here legally in the first place, but then you're not allowed to then enforce the other immigration laws?
thank you. And I'd refer members of the committee to footnote 2 of our written testimony, which says that according to ICE's own records, between fiscal year 2008 and 2012, it erroneously issued 834 immigration detainers against United States citizens and 28,489 immigration detainers against lawful permanent residents. So the point is that ICE makes mistakes, and people who are lawfully in this country can nonetheless be negatively impacted by the enforcement of the immigration laws. The other question that the chair had asked was to point him to a person who has been deported who shouldn't have been. We represented a person who was in removal proceedings and had raised defenses to removal on the basis of the Convention Against Torture and other associated laws, which are basically defenses to immigration. And after his case had been accepted for review from the BIA to the First Circuit Court of Appeals had issued a stay of his removal. And nonetheless, the government deported him in violation of that stay, causing him to spend over 6 months in a Salvadoran prison, where conditions are sort of as you'd imagine. And that led to a round of briefing at the First Circuit as to whether the Attorney General or Secretary of Homeland Security should be held in contempt of court. In sum, I'd just like to say that people who are out of status may be victims of crimes, they may be witnesses to crimes, and allowing a local police department to enact policies or procedures that allow them to take into account the complex realities of the communities that they're sworn to protect preserves local control, which is, I think, a well-established New Hampshire value, and inclusion to the community by allowing people, regardless of immigration status, to feel safe reporting illegal acts that they say to the police. So that concludes my testimony, and I'd be happy to take any questions if there are any.
Representative Roy?
Thank you, Mr. Chair. Thank you for taking my question. As an attorney, is it your opinion that it's good policy to allow localities, let's leave immigration out of this, is it good policy to allow localities to decide which laws they will and which laws they will not comply with from the federal government?
So I think what I would say is, as an attorney, immigration law is the exclusive domain of the federal government, and our system of government in New Hampshire is such that generally localities are free to use their own resources the way that they best see fit. And I think, in general, allowing police departments, absent some overriding concern, to determine the best ways to police their communities is good policy.
A quick follow-up, please.
You're recognized for a follow-up.
Thank you, Mr. Chairman. I'm referring specifically to detainers. I agree totally local police should not be enforcing federal laws. But to the detainer question, should localities be able to instruct their police departments, do not comply with federal detainers, because it's a federal law? Should we be doing that? In the same vein as, should we also maybe perhaps say, ignore the Second Amendment laws from the federal government? We have our own here in New Hampshire.
Sure. So I guess the best way to answer that is that courts across the country have found that local police officers violate their state constitutions by arresting someone on the basis of an ICE detainer, because an ICE detainer is not an arrest warrant issued based on probable cause and issued by a neutral and detached magistrate. And so in New Hampshire, a police officer is not free to generally make an arrest except in limited circumstances, when they have a warrant or when a felony is committed in their presence and they have probable cause to believe that, right? I think that a locality could easily look at those cases that we cite in footnote 4 of our written testimony and determine that they may be opening themselves up to liability for violating someone's state constitutional rights by using state actors who are not authorized explicitly by federal law to enforce these immigration detainers, and thus may be violating the state constitutional rights of someone. So I guess I'd say it is good policy to allow police departments to make their own judgment and avoid violating state constitutional rights of people.
Thank you.
Representative Lang?
Thank you, Mr. Chair. Thank you for taking my question. So I want to go back to this idea, this concept of public policy and ignoring laws. So I guess if the city of Concord here decided to pass and say the city of Concord Police Department, which is funded by the city, cannot assist ICE in any immigration laws, and then ICE shows up at the doorstep to the local police department and says, we've done an investigation, we want to go raid this house or this location, and Concord PD says, nah, I'm not going to do that, we can't, I'm not allowed to, and puts those INS officers at risk in a community they don't know. Do you think that's good policy?
So I think, number one, that I'm not aware of any police department saying that we would not provide that kind of courtesy for an arrest warrant raid being taken by federal partners. I think what we're talking about more specifically is more likely is a town or a police department saying, we have a policy of just not asking people what their immigration status is. And I think that is good policy.
Follow,
Oh, I apologize. I was trying to
Should
look
probably
at the
turn my own
question.
microphone on when
follow
I
up,
say that.
please.
Yes, recognize for a follow-up.
So again, but what this law, if enacted, would do would prohibit a city council from putting restrictions on police departments from assisting federal law enforcement officers, right? I won't say it would require them, but the law enforcement officers would be free to act in concert with federal law enforcement agents. Absent this law, a city council could potentially put in a rule that would prohibit them from doing it.
So I think this bill, which is one sentence long, it's not entirely clear to me that that's what this bill does. I think that a fair reading of this bill is that any police department saying, we're just not going, we'll honor detainers from ICE, or, we'll assist federal partners as a rule when they ask us to go on I guess, a raid with them. That may be covered, but also if a police department were to say, we're just not going to ask people who we interact with when they're reporting crimes about their immigration status, I think that arguably discourages the enforcement of federal immigration laws. I think that the law as written is so vague that a police department may not feel that it could enact a policy saying, we're not going to ask victims of sex trafficking their immigration status, for example.
Representative Rung?
Thank you, Mr. Chairman, and thank you for taking my question. Following some of your comments, one of the concerns I have that I want to ask you about is if this bill passes as it's been submitted, would it risk costly litigation on the part of the state?
It could, or probably more likely local communities who are the ones who would be facing Section 1983 lawsuits, such as the ones that we brought in the case that I mentioned before of the gentleman in Exeter who was arrested after he assisted the police department in its investigation. And so, yes, I think it could.
Okay, thank you.
Lead to litigation.
Representative Newman?
Thank you, Mr. Chair. Do you agree that, the premise is that we must enforce all laws, and so I'm having a confusion between this enforcing federal laws and just enforcing laws in general. I mean, I don't think it would be good policy for them to have a bill that said you couldn't enforce speeding laws or some other law.
Is there a question coming?
That's my question. Do you agree with that? Would that be good policy? Because the police, don't stop everybody that goes over the speed limit, so I'm having a trouble with this.
I guess what I'd say is that it would be an impossibility for the police to enforce every law all the time, and probably not what any member of this committee would expect the police to do in every circumstance. And this bill, if passed, would take away that discretion from the police departments and the local control that we value in New Hampshire.
Thank you.
Representative Conley?
Thank you, Mr. Chairman. Thank you for taking the question. This is an expansive bill, and I read and a question is coming, but when it says that there shall be no action by person, employee to prohibit, limit, in any way restrict or discourage the enforcement of federal immigration laws, would failing to ask someone's status, as you've noted, is common policy in many departments, would that violate this statute as you read it?
I think it might. I think that the statute might also prohibit, for example, the governor from saying, if he ever or she ever were to choose, we think that the federal government should prioritize X, Y, Z immigration laws. I think it's beyond just a local police department has to comply with a request from ICE to go on a raid. It's discouraging the enforcement of federal immigration laws. It's pretty broad.
If I may follow up, that
You're recognized.
Thank you. And you sort of honed in on what I was getting at with the discourage question. That's sort of an open-ended word. So is that then, if this were to pass, would that then force our departments to take certain actions so that they did not violate this statute?
I think it very well may.
Representative Burt?
Thank you, Mr. Chairman, and thank you for your testimony. If I understand, you're an attorney.
Yes, sir.
Yep, thank you. In this one sentence, 4 lines, I don't see where it says that if this passed, every police that pulls over somebody has to ask immigration like Nazi Germany. And being an attorney, I would think you could answer more, yes, this is what the law is, or this isn't. Not, it could, or it may. I would like more of a direct, if you could, where is it in these 4 lines that they have to stop people of any color and say, where is your, what is your immigration status?
So I guess I'd start globally by saying that sometimes statutes are not clear and need judicial resolution. And not being a judge, I can't tell you how necessarily a court would definitively interpret the statute. But my reading is, if a police department has a policy that says, we are not going to ask every single person who we stop their immigration status, or if they have a policy that says, we are not going to ask victims of sex crimes their immigration status, that discourages the enforcement of immigration laws. I think that's a fair reading of the statute, or restricts the enforcement of immigration laws. I guess my answer is that restrict and discourage are undefined in the statute.
Thank you.
Representative Roy?
Thank you, Mr. Chairman. Thank you for taking another question. I actually agree with some of this vagueness. What would the ACLU's position be on this law if it just said New Hampshire law enforcement is prohibited from ignoring detainers on someone who's taken into custody on another crime? In other words, not detainers that are discovered like your client in a store or anywhere else. Only if the person were arrested on a local state crime by a local law enforcement and they saw a detainer in the system, they're prohibited from ignoring that. What would the position of the ACLU be on that?
Sure. So if I could just start by, unfortunately, caveating what I'm about to say, which is that I can't give you an official position as to the ACLU of New Hampshire without talking to all my colleagues. But I can tell you what I think it may be, or sort of give some rough approximation.
I won't hold you to it.
Sure, thank you. And we'd be happy, I should say, we'd be happy to, speak with you directly or work on any particular language if that's something you're interested in. One concern that we would have with what you just suggested is if the person's in custody but would otherwise be released, is their detention prolonged as a result of the immigration detainer? So, for example, if a person is otherwise being released from Valley Street Jail, and a thing pops up and it says that there's an immigration detainer, and they call ICE and ICE comes over. ICE is in Manchester, so it may be quick and it may not prolong their detention. If the same thing were to happen when a person is being released from the jail in North Haverhill, New Hampshire, in Grafton County, it may take ICE several hours to get there. And so it may be that the jail is otherwise extending their detention by a matter of hours in order to comply with the ICE detainer. And so I think we would have concerns with that because it would be a detention not otherwise authorized by state law and not based on any sort of neutral and detached magistrate's finding of probable cause. I hope that was clear enough.
If it was, if the chair would permit, just quick.
You may make a follow-up.
So, I understand. So, under that theory, though, if anyone is inconvenienced by the detainer, what good are these detainers if nobody can act on them?
Well, I guess I would reject the premise of your question that being detained in jail is an inconvenience. I think it's a greater intrusion into someone's civil liberties.
Well, if you were getting out anyway, and you had to stay an extra hour.
I think that is a compensable damage.
We agree you're an attorney, but regardless.
I will say that if you have language that you want us to take a look at, we are always happy to do that.
Thank you.
Thank you for testifying. If the chair may inquire with a question.
Sure.
Thank you for taking my question. I understood your testimony that it's good policy to allow police officers to exercise judgment and make judgment calls. Is there any thought on the idea, though, that if you had the reverse policy, where it was the standard to not enforce any immigration laws at all, such as in Dover, what is your opinion on a policy like that?
I'm not sure that I'm in a position to announce an opinion on Dover's police policy, which I haven't reviewed.
If you haven't reviewed it, that's a fair answer. Thank you. Representative Conley.
Thank you, Mr. Chairman. We don't have law enforcement in the room that I see, so I'm not sure who best to direct this question, but I have heard conflicting testimony about what actually happens if somebody with a detainer has an interaction with law enforcement. What would happen in this state? I've heard different things from different witnesses, and I'd love an answer if you can provide that. And I don't see law enforcement to direct that to.
I think it depends on the department that arrests them. Some departments may check, some may not. Some may honor those, some may not. I think it probably is a case-by-case determination is my guess.
Representative Newman.
Thank you. Thank you for taking my question. So the police now have some discretion or some limited discretion to do what you just testified to. Do you think that this bill would limit that kind of discretion?
Yes.
Thank you.
Thank you for your testimony. The witness is excused.
Committee now calls Asma Elnwy.
Finally. So, hello, committee, Representative Abbas, and committee. My name is Asma Elnwy, and I am with Rights and Democracy New Hampshire. And I am also speaking as an immigrant who understands many of the fears that immigrants live with as they are misunderstood minorities oftentimes in this country, including understanding that oftentimes because of stereotypes or mischaracterizations of us, we are seen as a threat. As a Muslim woman whose community often gets labeled as violent, I still face interactions, assumptions that I could be violent and profiled because of my identity. When I was a child, I remember a woman trying to reach out to my parents, basically was the landlord, and she told me that she would call police and tell them that I was illegal, and that we were illegal. I was so confused. I did not understand what she meant. The strategy she employed of calling police was intended to threaten us of deportation. This very thing happens to many people, including victims of domestic violence. Oftentimes, they stay in abusive situations because of fear that police involvement could mean deportation. So actually, this does affect people who are in situations with domestic violence. I know there are laws to protect people who are in domestic violence cases to keep them in the country, but as someone who is an advocate for domestic violence, I am actually certified in the state of New Hampshire and Vermont. I can tell you that that process includes getting a letter from the police department or a judge. So not all women get that, and so again, not all women go to the police department because sometimes they won't give it to them, right? I did eventually become a citizen at the age of 16. I need people to know that. For many immigrants, there is not a pathway to citizenship for them. And I do want to go back and just make sure that to be clear that a human being cannot be illegal. And so oftentimes when we talk about people that do not have documentation, we'll just call them undocumented for those who want to do the right thing and just don't know what language to use. We can just say undocumented. Because when we call people illegal, we are basically saying their humanity is criminalized, right? So we're just saying that their humanity is criminalized for being human, and that's just crazy, instead of the act of doing something that is not legal. So there are several important points I want to make today. One, most undocumented immigrants have actually come to the United States legally and found themselves undocumented because of not being able to renew documents because of language barriers, for example. Also, there are about 10 to 15,000 undocumented immigrants in the state of New Hampshire. Undocumented immigrants boost our economy. Undocumented immigrants have contributed $14.3 million in federal taxes. And guess what? $6.1 million in state and local taxes. And that is research done by New American Economy that I can send to you. We cannot continue to use immigrants for their labor, their contributions. We benefit off their backs, but yet we devalue their humanity. It is time for us to demonstrate our appreciation of the labor and the sacrifices of immigrants, many of whom are essential workers and have carried us through this pandemic. I'd like to share a story that an undocumented immigrant has shared with me. She came to the United States as a child. She did not know that she was undocumented until she got older, as is the experience of many undocumented people in the United States. She told me a little bit about her struggles. She said when she goes into a car, she has to make sure everything is right. If it's dark outside, she has to check her front lights, her rear lights, because she never knows. If a police officer stops her, she is afraid that he will think it's law to call immigration enforcement and have her deported because, you know, they're taught they have to follow the law. And unfortunately, like some other people mentioned, we're talking about criminal law is the federal policy, and then we have civil law. To be here undocumented is not a criminal offense. It is a civil offense. And that's what we're talking about. So when we're talking about also detainers and this confusion about detainers, we have to understand that detainers is not a legal warrant. That means there are some detainers that have to do with a criminal offense. Somebody committed a crime, right? And we have to, by law, make sure we share that information. But when we're talking about detainers for a civil offense, that means someone is just considered a criminal, or we just want to punish them simply because they are undocumented. And I shared a story how some people, no fault of their own, how they wound up in this country. That is ridiculous. And that is what we're addressing here today. We are not saying going against federal criminal law. But what we are saying is it is a civil offense, not a criminal offense, to be here undocumented. And so her story is just one of many. I used to live in the city of Lebanon, New Hampshire, and we passed an ordinance to ensure that police do not share information with Immigration Customs Enforcement. And again, not all information. I'm talking about information that has to do with a civil offense, just being here. So that means if a police officer stops someone, and again, we talked about me being racially profiled and other people, brown and black people, and when police officers stop them and they do not have documentation, they might call Immigration Customs Enforcement. And this is saying do not. And this has helped our community in Lebanon. It's helped immigrants feel safer. And so that is why we are strongly opposed to this crazy bill.
Representative Klein-Knight.
I move we ITL this bill.
Second.
We're there. Come on. Put it in your hearts.
I'm going to call the meeting to order. Listen, Representative, first of all, to the members on the committee, please only speak if you are recognized to speak. That's one. Number two, we're not in an executive session, and I believe the member knows that. We're in a public hearing. There's members of the public who are sitting in the audience that haven't even had an opportunity to testify yet. And they've been waiting patiently. I believe we at least owe them, those members of the public, the respect to let them speak, whether in support or in opposition to the bill. So I'm going to rule that out of order. And even if we were in an executive session, you would still need to be recognized to make that, which we're not. So that's my rule.
Thank you, and I apologize to the public and the body.
Thank you, Representative Klein-Knight.
Mr. Chair, parliamentary inquiry.
I was going to ask if the witness wished to continue. her testimony. I'm not,
Well,
I don't remember if you
maybe I'll
concluded
just
or not.
say, yeah, thank you, Representative Abbas. I will just say, like any one of you, every single one of you, I should say, every single one of you, if you felt unsafe, wouldn't you take your family and leave? And I want us to think about that. People are in this country not because they're trying to take resources away, and I talked about they contribute here. They're fleeing violence. And oftentimes it's something that we've done in other countries that has caused people to flee where they are and to seek safety. So let's offer that humanity that we should offer every single person and welcome people. They are contributing members of our society. And until we fix our immigration system and ensure a pathway to citizenship, everyone deserves safety.
Thank you for your testimony.
Thank you.
Representative Roy, you want to be recognized for a question?
I do, thank you. Will you take the question?
Yes, who are you?
I'm way over here, behind the
Oh,
chair.
okay, sorry.
You made a statement that being undocumented is a civil infraction. Is it always a civil infraction?
No, it is not always a civil infraction. And what we're asking for is the fact that when it is a civil infraction, leave people alone. That's what we're asking for. Immigrants should be treated like every single other person.
Thank you for your testimony. Did you have a question for the witness? Or-
Sorry, Mr. Chair, I still have that question for you, but I don't want to step on what is happening with our witness, especially since she's a constituent of mine.
That's right.
Be extra
That's
nice
right.
to the, be extra
Proud
nice to the witness.
constituent.
All right, so if you don't have a question for the witness is excused. You may be recognized for a parliamentary inquiry.
Thank you, Mr. Chair. And again, I apologize to the witness for stepping on her testimony because that is a faux pas. She's my constituent. Anyway,
I
genuine.
saved you. That's that.
Thank you. I appreciate that. I really do. Genuine question because I don't know the answer. Nothing like up my sleeve or whatever. Who calls executive sessions and how? Is it only ever the chair or can anyone else do that? And if we don't know the answer for sure, can we check with
We
the
can
clerk?
I know that's a complicated answer. It could be noticed. It's noticed today that an executive session may follow, but we're still in the public hearing. So we wouldn't end the public hearing early to vote or make a recommendation to an executive session to the public hearing is concluded.
Okay, but my question really is, whom among us, I hope that's correct English, can call executive session?
The chair of the committee would have to open the executive session.
No one else can, unless you're not here, I assume.
Then it would go to the vice chair of the
Right.
committee, and then if the vice chair and chair were not here, it would then go to the ranking member of the majority party.
Okay, thank you.
Next witness.
We now call Francisco, looks like Goulet. Goulant.
Hi, good afternoon. That's the house. My name is Francisco Goulart. I'm coming from Brazil. I live in the United States for, just on my little story, I live in the United States for 33 years and in Merrimack, New Hampshire for 23 years. And my three family give to the United States four people for the army, 2 working for the Afghanistan, and my little story, when I arrived in the United States in 1989, I got a visa for business, and now I have a business in Nashua, give you job for 5 people, and let me see, and just remember for the people in this house has the hair white like me, because my country, Brazil, after Civil War, opened the door for the American people, and they found and they planned for the small city in my country, they called Americana, and they opened the door for America. It's now, I don't know why this House vote for about immigrants. Immigrants is not people danger. Immigrants is people contribute for the growth for the economy of the United States. And that's the reason why I'm here and tell myself why for this House vote for this bill, because immigrant, illegal or illegal, is no danger of people for this in New Hampshire, because New Hampshire and the United States and is made by immigrant people. For this is my testimony for this House right now. I'm opposed for this bill. Maybe my English is not very well, but this is my testimony. And finalizer, I have 3 kids and grow up, 2 born here, 1 born in Brazil, enter United States 18 months old. Now all study university and grow up here and contribute for the United States. My family, the total for the United States about 50 people, and they all pay the bills, all working, all pay the bills, pay the tax, and so no have for the United States. All people working legal here, but it's not take nothing from the government. All pay for the care, the money, and the working in the United States. This is my testimony. I'm opposed for this bill. That's all my testimony.
Thank you for your testimony. And if you don't mind, just please hand up the pink card to one of the members. Oh, my apologies. Does a member have, any members have, the witness is excused? If the members on the committee can do their best with the electronic devices, I do have the discretion to have them all turned off, but it is very distracting. I'm trying to find the stack of who to call next, but you're back.
Committee now calls Sandra R. Pratt.
I'm the last one on the list, so
No?
bear with me. So, I'm not a lawyer, I'm not an expert in anything, but I'm here because I am opposed to this bill. So I will say it before I give my testimony. I am Sandra Pratt. I live in Nashua, New Hampshire for about 21 years. I came to this country with the legal status to study English. I wanted to continue my education in Brazil. So I came here to learn the English and go back and finish my education there. But, well, I ended up getting married, ended up staying here. I have 2 children. I have a family. I have a lot of friends. There are documented, not documented whatsoever. They are immigrants like me. I didn't have this documentation problem because I got married, thanks to my husband. I work legally my whole life in this country. I am legally here speaking today. So what I wanted to say is about a little bit, I know you're all tired, I am tired too, but it's a big responsibility to sit on a chair that you're sitting. And I am here representing a lot of people. I'm representing the individuals that I serve from Gateways Community Services, individuals with developmental disability, in my own Brazilian community from the state. So I just wanted to say that there are so many other more important laws that you should be considering and worry about it than this law that is just confusing to me, and I already say that I'm opposed to that. Laws, well, I'm going to talk about microaggression first, which is like, today I watched a video and it explains a lot, so you can just I will be brief. The mosquito bite. Every time people say, "Where are you from? Where is your accent from? Do you have documents? Do you have driver's license? Whatsoever," it's like a little mosquito that bites you. When I start working here legally at a pizza place, the lady, the waitress, would scream at me, and my boss would say, "She's not that. She can't hear. She just doesn't speak English." So microaggression is like that little mosquito bite that you get every day. There are a lot of people here are in this, this position, getting this mosquito bite, getting this microaggression like every day. So my point is, people call me now thick skin because I really don't care anymore if my English is good enough. I just care about, I do have driver's license, but I do care about people that don't. So that's where I'm here, because I care about the people that are not documented, or that are diverse, there are whatever background, to be here for them. So I just think it's a big responsibility to sit on the chair that you're sitting, and that you really should be worrying about laws that will encourage equity, inclusion, and diversity, that will include, and that will encourage, that will provide individuals with developmental disability that I serve every day with inclusion of hearing, vision, and dental care. That's what I'm really concerned about as well. And also the driving license. Every single person, every individual should be able to drive if they pass on the right written test, if they pay their fee, if they know how to drive, the practical test, they should be able to drive. So there are other bigger issues. Immigration is very, it's very confusing. It's a federal law. There's not, a lot of smart lawyers get through the laws and do this and do that. People can change their status. I don't understand that. My friends here are lawyers. They know better. But it's so complex, and it's so confusing, and it's so not right. If you can't have a green card, why can you have a gray card and be able to drive, be able to work, be able to leave? So you're tired, I'm tired, so I apologize if I couldn't express myself well enough, but I'm opposed to this bill. Thank you. And if you have any question, I'll be happy to answer. No question? We're all ready to go home? Kill it.
We're not going anywhere. The committee now calls Sherry Rendall.
Good afternoon, Chairman Abbas and other distinguished members of the committee. Thank you for allowing me to testify today. I'd also like to thank the bill's sponsor, Representative Tony Piemonte, and also Representative Janine Nutter, who's here for support as well. My name, as you heard, is Sherry Rendall. I am the Director of State and Local Engagement at the Federation for American Immigration Reform, FAIR. FAIR strongly supports House Bill 1266. We are a nonpartisan nonprofit organization of concerned individuals who believe that our immigration laws must be reformed to serve our nation's interest. We were founded in 1979. We have 3 million members and supporters nationwide, including 4,000 in the state of New Hampshire. And before I get started into my testimony, I want to say we are a nation of laws. We support that. And I also want to say that our organization supports legal immigration. We are the most generous nation for those who want to come to the United States. In fact, right now, I'm not sure if you all know this, we accept over 1 million immigrants annually. So we definitely believe that there should be a legal way into the United States. We do believe that there are finite resources, and we need to, as a country, determine the best interest. Now to talk about HB 1266. It will prohibit jurisdictions from employing dangerous policies that provide a safe haven or sanctuary in which illegal aliens can live or work without fear of apprehension from federal immigration authorities. This is not about enforcing our laws. It's about prohibiting policies that actually will not allow for the federal immigration laws to be enforced. Sanctuary policies come in all shapes and sizes. Some are written, some are not. Some are enacted through local laws, while others masquerade as welcoming resolutions. Some even appear as internal policies for law enforcement agencies. However, they generally bar state or local officials, including law enforcement, from asking lawfully stopped or detained individuals about their status, or reporting or otherwise cooperating with federal immigration officers. Regardless of how they're enacted or what form they take, the common factor is sanctuaries place a greater emphasis on the welfare of illegal aliens than the welfare and safety of citizens and legal immigrants. Hundreds of cities and municipalities have declared themselves welcoming. They claim that they don't interfere with federal law enforcement, but that's simply a fig leaf. Welcoming or sanctuary cities actively impede the enforcement of our federal immigration laws and often attempt to block free communication between state and local officials and federal immigration officials. Since 2017, in New Hampshire, there's been a proliferation of counties and cities, including Cheshire County, Deerfield, Dublin, Harrisville, Lyme, Manchester, Hanover, and Lebanon, that do not call themselves necessarily sanctuary cities, yet their practices make them function as such. Enacting 1266 will ensure these jurisdictions cannot prohibit or restrict communication with immigration officials. Unfortunately, illegal aliens that reside in sanctuary cities do not necessarily remain solely within that locality. In the sanctuary city of Lawrence, Massachusetts, which is only 4 miles from the New Hampshire state line, dozens were arrested in 2018 on federal on federal drug and firearms and immigration charges. In addition, the authorities seized 10 kilos of fentanyl, enough to kill half the state of Massachusetts. According to then U.S. Attorney Andrew Lelling, Lawrence is a clearinghouse for illegal drugs pouring into the state of New Hampshire and Maine. New Hampshire has the 3rd highest rate of opioid-related overdose deaths in the country, according to the National Institute of Drug Abuse. Many of these are related to fentanyl, the majority which is manufactured in both China and Mexico and brought in the states across our southern borders. According to John Delena, an associate agent in charge of the New England Field Division of Drug Enforcement Administration, cartels like Mexico, Sinaloa are making decisions that are going to affect what happens in New Hampshire. He says they have better research and development than any Fortune 500 company. Furthermore, shielding illegal aliens necessarily endangers innocent lives. There are roughly 3 million criminal aliens living in the United States, that is, illegal aliens with criminal records, in addition to their unlawful presence in the country. And nearly 1 million of these have final orders of removal. These criminals should not be able to continue to live in communities and engage in further criminal activity. Likewise, the assumption that illegal aliens commit crimes at lower rates than American citizens is simply not true. In a recent study that FAIR did of the State Criminal Alien Assistance Program, or SCAP, it was found that illegal aliens are more likely to be incarcerated in state prisons and county jails than U.S. citizens and legal immigrants. In fact, the report found that in the states examined, illegal aliens are incarcerated up to 5.5 times as frequently as citizens and legal immigrants. Additionally, it found that the states with higher incarceration rates of illegal aliens are also the states that boast the most number of sanctuary jurisdictions. According to the Office of Inspector General, in fiscal year 2019, immigration officers nationwide made 143,100 arrests of aliens charged with or convicted of 489,100 crimes. These crimes included 45,800 assaults, 6,650 sex crimes, and 1,923 killings. Opponents of anti-sanctuary policies justify shielding illegal aliens from our immigration laws by saying it's necessary for law enforcement to build trust within the community. However, state and local cooperation with ICE does not reduce the number of non-citizens reporting crimes or coming forward with testimony about being criminalized. As mentioned, besides the fact that anonymous tips can be given, there are already a number of programs that state and local police can use to encourage victim and witness cooperation by granting lawful status to illegal aliens who aid in the prosecution of criminals. They may qualify for U, T, S, or VAWA non-immigrant visas, which would allow them to apply for permanent legal status in the U.S. Sanctuary policies actually prevent illegal aliens of crime from taking advantage of these programs. Additionally, according to a recent report by the Center for Immigration Studies, the data from the Department of Justice National Crime Victimization Survey shows that immigrant victimizations are just as likely, and in some cases more likely, to be reported to police than crimes against native-born. They found that 62% of all serious crimes against immigrants were reported, compared to 53% against native-born Americans. Finally, sanctuary policies tell individuals that despite violating federal laws, law enforcement and other government officials will ignore them. Just because the regulation of immigration is a federal issue doesn't mean the state and local enforcement agencies must overlook immigration violations that harm their communities. There is a cost associated with sanctuary cities, which act as a magnet for illegal immigration. According to FAIR's 2017 cost study, New Hampshire spends $86.9 million annually. And that takes into account the amount of money they spend in taxes. HB 1266 is needed to clarify New Hampshire's public policy of cooperation with federal immigration authorities, and for this reason, FAIR supports the legislation.
Thank you for your testimony. Representative Bolden.
And Mr. Chairman, I hope that this question is not out of line, and I'm only asking in genuine curiosity.
I hope it's not out of line either.
Thanks. And so that's why I'm prefacing with that, is that I don't have any malintent. But I gather that you're new to the building. Earlier I told you where the bathroom was, I think, and I love your shoes. And in the New Hampshire State House, lobbyists wear orange badges, and you don't have one on, so I was just wondering if you're a lobbyist for the organization.
I'm representing FAIR in its capacity as an organization to state our opinion on legislation. We do have members in the state, but I'm not a registered lobbyist in New Hampshire.
The representative from the ACLU did, but I understand the point that was made, and I would apologize. I think I only recall one witness actually wearing a orange badge. It's my job to actually enforce that. I kind of there's some oversight on my end, so I apologize for that. But I can't go back in time and fix that. But I do believe it would be unfair now to strictly enforce it on this one witness. But you're recognized.
I personally don't know if you need to be wearing an orange badge, but if that's the case, would you consider looking into it?
I will certainly look into it.
Okay, Representative Bolden, the questions are supposed to be asked are to ask or obtain information about the bill or information relating to their testimony. Thank you. Representative Schultz.
Thank you, Mr. Chair. Since I mentioned this earlier, I wanted to give you the opportunity to address this. So FAIR has been labeled a hate group by the Southern Poverty Law Center since 2008 for its ties to white supremacist groups and attacks on non-white immigrants. How does it feel being a part of a group known to be a hate group.
So I will address that.
First of all, I'm instructed not to respond to the question. I'm deeming the question out of order.
Can I rephrase it, Mr. Chair?
With the prior member that asked the question, the questions are related to the substance of the bill and the substance of the testimony provided by the witness. I'm ruling that that is not related to either the testimony provided or the bill itself.
Okay, that's fair. May I ask a different
That's
question?
That's the ruling that I made. You may
Okay.
recognize for a follow-up or a
Thank you,
different
Mr.
question.
Chair. I am a representative from Concord. We're not too far from my district's border. So as someone who doesn't live in New Hampshire, do you feel you understand the local state laws and local community laws and our high property taxes?
I'm going to deem that question out of order as well. We have consistently had members of the public who reside out of state come.
But
At least in this committee. I don't want to speak for every committee, but it's happened quite frequently. So again, if we were going to,
I'm not sure how to rephrase that. Since this impacts our taxes, I thought maybe she had an expertise in some way to know how we can pay for this.
I'm deeming the question out of order as well.
Okay, that is your right as chair. Sorry, Mr. Chair.
May I just mention something on detainers? Or is that out of order?
Where
Sorry.
testimony is concluded, but
Sorry.
Representative Klein-Knight? Oh, Representative Harry Gathering, you're recognized.
I don't know whether this is a point of order or is just a question to you.
It's recognized for a parliamentary inquiry.
Well, you can tell me if that's it, okay? We've sat here all day and we've listened this evening, listening to testimony about that terminology, illegal alien, and the fact that you allow people, and that was part of what we were talking about here. You have the right not to allow that type of testimony that's so offensive to many people in this room. And I'm very serious about this because enough is enough. Wait, hear me out. No, please hear me out, okay? It's the same way that if we're sitting in this room and someone wants to use the N-word, okay? It's just as offensive. So I'm just saying that, you know, we have to do better than this if we represent the people, all the people, as a committee.
Before I respond to that, I just ask that the members of I'm going to call the room to order again. I'm asking the members in the public to not be yelling stuff out. It makes it very difficult for the committee to do its business here. To the extent that that was a point of order, it should have been made early, but I'll address it. I understand that some people may find the term offensive, illegal alien. However, under federal law, that term is constantly listed as a legal term. I'm not saying that I agree that they shouldn't change it, but that is something that is listed under several laws. So when someone does make that, I'm not the one that wrote the federal laws. I'm just explaining that when people do use it in this context, it is still a legal classification. I'm not saying that they shouldn't change the legal classification. So my point is, it's hard to. I wouldn't rule someone out of order for using it in that context.
You have the power in this room to make that type of decision. Can say the terminology is not welcome today or whatever you need to say, so that it would not be offensive to everyone sitting in this room. That's all I'm saying.
The best way to address that would be to contact our federal delegation and have them sponsor legislation at the federal level to remove that language from the federal laws. Because the people who do use it, I understand that what people do find it offensive, but when it's written in law, that's where some of the confusion comes from. So I appreciate the point made by the
Mr. Chairman, can I make a point of order, please?
Representative Burt, you were recognized for your point of order. Please state it.
Mr. Chairman, I know I have questions of the person giving the testimony at this point. So are we going to do point of orders all night, or can we get back to the business and do point of orders after everybody wants to leave?
Respectfully, I'm not sure that's a point of order.
Correct.
That
Probably
was made.
isn't.
So your point of order is also out of order.
Thank you.
it's a parliamentary inquiry, it sounds like. And a point of order has to be addressed when raised, and I could actually find a point of order to be dilatory, which I'm considering it. I don't find the parliamentary inquiry / point of order by Representative Harry Gathright to be dilatory.
You know, Mr. Chairman, I just see a lot of hands up, and the witness, you know, is sitting patiently, waiting for my question, and I'm sure anybody else's question. And, you know, it's just rude in my eyes that we can handle this internal stuff after the hearing.
Do any members of the committee have any questions for the witness?
I have a question of the chair.
Before that, do we have any questions for the witness? Representative Rung, you're recognized to ask a witness to the question.
Yeah, that's all right.
Thank you, ask a question to the witness.
I'm just thanking you for allowing me to speak, and thank you for taking my question. You cited a lot of data on the national level, but I was wondering if your organization had data that's New Hampshire specific. And I noted just from the national numbers you gave me, do you have anything specific to New Hampshire on the number of taxpayers or taxes spent in New Hampshire or paid by, I don't know, you know, the people, jobs they hold, how many jobs are held in New Hampshire, and the percent of arrests in New Hampshire from undocumented immigrants?
Thank you for that question. The number of arrests is very hard data to get a hold of. It's not always reported, so it is difficult to get a hold of. With respect to the cost to New Hampshire, I did cite that it was $86.9 million is what it costs after taxes. So it's $132 billion nationwide, and then 86.9 million in New Hampshire. And that's after you account for all the taxes that they do pay.
Okay, follow up. Mr. Chair.
You recognize for a follow-up.
Okay. Do you know, one of the things I included in my question, but I'm sorry, it was long, is do you know how many jobs are held in New Hampshire by
illegal?
Yeah, well, I'll say undocumented. I'll be respectful and just say undocumented immigrants.
Excuse me, it's not, we don't need to imply anything. That issue's been addressed already.
Okay, thank you, Mr. I just didn't want to use a term that people see as.
You can use the term undocumented. I use that term, that's it.
Okay.
That's it. I understand.
Okay, thank you. So do you know how many jobs in New Hampshire are held by undocumented immigrants?
So I do not have that statistic. Reality says there should be no jobs held by those here illegally according to federal law.
Okay, thank you.
Representative Newman, you were recognized to ask the witness a question.
Thank you, Mr. Chair. That's exactly what I intended to do. You mentioned in your testimony earlier, you gave a list of cities in New Hampshire that you said, I believe, act like, now I've lost the term, the sanctuary cities, but are not. I'm just wondering if the data that you used to make that statement was based on an examination of written policies that they have, or could some of those policies just have been verbal policies, like, we don't have a lot of money, so your priority is go to the most serious things and kind of leave the immigration things like that? Were they written or verbal, or do you know?
Thank you for that question. They were written policies mostly, and they were based on the fact that we had looked at, actually had to research into the states and look at what the statements were. So while they don't call themselves sanctuary in the term, they are acting like sanctuary cities, and they have policies written that have interfered with or prohibited communication, free communication on immigration issues.
Follow up, Mr. Chair.
Representative Newman, you were recognized for a follow-up question.
Thank you. Is it your opinion that the way this bill is written, where it says prohibited from acting in any way that would discourage enforcement of federal immigration laws, do you believe that this law would then prohibit cities that don't have written policies, but they say the same kind of thing, that if we don't have the money and don't do the most important laws now and don't do the immigration stuff, that kind of verbal, non-written documentation would also prohibit those cities from being able to tell their police that that is their policy?
If it's from the council or local governments basically verbally telling the law enforcement that they can't enforce or communicate, yes, that's an issue, because you are prohibiting free communication and cooperation with federal immigration officials. And in fact, state and local governments and localities, law enforcement, cooperate with federal officials on many, many levels, including Bureau of Alcohol, Tobacco, and Firearms, including marshals. There are many times when there should be cooperation with our federal partners on the local and state level. And so we want to ensure that there are policies in place that prohibit a locality from not being able to cooperate or communicate.
Representative Klein Knight, you recognized.
Thank you, Chair. You mentioned a lot of money being spent, and so that's very good to know. And then you said 1 million people, what was, you said 1 million people?
Have final orders of removal.
Yeah, how many undocumented individuals did the states let in last year? And of that number, how many were criminals?
You're asking how many, I'm sorry, for clarification purposes, you're asking me how many people New Hampshire let in illegally?
How many undocumented people did the, because you're national, why don't you can just tell us in the United States, if you have that data, how many undocumented did we let into the United States of America last year? And of that number, how many were actual criminals? Because this is all based off of their criminals, right?
What we're saying is these are the people that we already know have final orders. They've gone through the process and they have final orders of removal. As far as those who have been admitted illegally, I don't believe that the federal government admits anyone illegally into our country, but there are numbers that anticipate the numbers of people who are here illegally. And I know last fiscal year, it was on track to end with 2 million people being here illegally. Out of those, I can't tell you how many have criminal records. I'm not sure that ICE or CBP even have the numbers of those at this point who have criminal records from those being admitted, who have entered our country illegally, if that makes sense.
Representative Klein Knight, you recognized for a follow-up question.
Thank you, Chair. So we don't have an accurate number of how many were criminals, but we need a law to prevent these criminals from entering.
Is there a question there?
Is that true? You feel like we need a law, but you don't even have the data to prove that we need a law.
I'm not sure that's a question. I'm just trying to keep the committee in order without letting it get out of hand, so I'm going to not give much leeway for the rest of the day. Representative Burt, you are recognized.
Thank you, Mr. Chair. I was going to start in-state, but ever since we're talking about the nation, I did want to mention that too. What will this bill do with the current administration, which I believe is following what President Obama and President Trump are pretty much doing? You know, the current administration is following mostly their footsteps with detaining people in jail and stuff like that when they come across the border illegally. What will this bill do with the current administration, what they're doing?
So with the current administration hasn't been enforcing many of our immigration laws. With respect to this bill, it will enforce the rule of law and make sure that we are not acting as a magnet for illegal immigration here in the state. It will ensure that there is opportunity to communicate and cooperate with our federal officials. Ultimately, it is the federal officials' determination on whether they pursue someone who is here illegally. It is their domain, not the state's domain. But to be able to keep the lines of communication open and not prohibit that communication, which some localities have done, is what's important.
All right, and a follow-up, Mr. Chairman? Thank you, Mr. Chairman. In this 4-line bill, 1 sentence basically, I heard a lot of talk that it's going to tell local police and state police if they pull somebody over, they can question their immigration. Can you tell me where that is in here?
This bill, from my reading of the bill, will give them the discretion if they choose to ask about immigration status, or it will allow them not to. It's their discretion from what I can see. The operative word are implementing policies. So if an individual is stopping someone on an individual basis, they have the opportunity to use their discretion. That's what you want your law enforcement to be able to do, and not have a blanket prohibition that they can't.
And just one short follow-up to that same question.
You may be recognized for a follow-up.
Thank you, Mr. Chairman. Do they currently have that right?
In most places in New Hampshire, they do, but in the localities that I mentioned, they don't.
All right, thank you.
Thank you. The witness is excused.
Thank you.
Are there any members of the public who are present who wish to testify that have not testified already? At this time, we will now close the public hearing on House Bill 1266. Representative Lang, do you mind approaching? You,
personal privilege of the entire committee.
I-
And that's it.
At this time, I'm going to call the committee room to order. At this time, we are going to open the executive session on House Bill 1388 relative to the unsolicited disclosure of an intimate image. Representative Conley, you're recognized.
Thank you, Mr. Chairman. I'd move out to pass on HB 1388.
Second.
That motion has been seconded by Representative Klein Knight. Do you wish to speak to your motion?
Briefly, Mr. Chairman, we have heard this bill now twice. We passed it last year, and I believe we ought to pass it again. Thank you.
Representative Perez, you're recognized.
Thank you, Mr. Chair, for giving me the opportunity. I would like to say that I want to see this bill pass. As someone who, in the end of 2020, when I was elected as a state representative, I was looking for a job that I can be flexible with me being a state representative. I went to a local business that I previously worked when I was here fresh in the country. The person who's the manager of that business asked me if I was looking for a job, and I say yes. That night, when I was home with my husband, I get a text from this person. Let me explain to you first of all. I'm a survivor from sexual assault from the age of 5 until 15 years old, before I married my abusive husband, ex-husband. When that manager from this establishment sent me a nude picture of himself, that brought back flashback from my sexual assault when I was little. It was so hard for me to show my husband what was happening at that moment. But I talked to some of my friends, and my friends told me that I should be open to my husband and show him exactly what happened. My husband told me that I have the right to put legal consequences to this manager. As a state representative, I was embarrassed to go into the police and show them what this manager sent me, a nude picture of his parts. And after that, he sent me a picture of him drinking tequila shots. I felt that I was sexual assault again. So that's why I support to pass this bill, because victims like myself, we need to be protected for this not to happen again. It is incredibly painful for someone who already have PTSD from being a victim of sexual assault and you feel like you've been abused again by a picture sent by someone who had the, I'm sorry. He called me the next day. He sent me a text asking me if I was still willing to take the job and work for him. How in the world I was going to be able to work for someone who already sent me a new picture of his parts and then make me feel like I already was getting sexual assault again? Thank you so much.
Representative Rhodes, you are recognized.
Thank you, Mr. Chairman. I just would like to point out to those in the room that don't know this, but this bill actually did pass. Not only did it pass our committee, it passed the House floor, and it also passed the Senate, the other body, and went to committee of conference. And a lot of the questions that were brought up earlier today, whenever we reheard the bill by the representative that resubmitted it, were actually addressed in the committee of conference that the attorney, I believe, spoke to. So I just wanted to remind people of that.
you, Representative. And for the members who weren't present for the committee of conference we had in the bill last term, the prime sponsor, the representative, actually caught a drafting error that saved us all from an embarrassment, because there was some talk of what maybe that would have legalized or made it a violation to send lewd images of a minor, which was not the intent of the sponsor. So it was a very good catch by the representative who filed this, and who's not even a member of the committee, but was on the committee conference with us. So again, and she doesn't have a legal background, so it was just an impressive catch. So we were all thankful that she did that, then refiled. The reason why this language was not accepted at that time was it really was more of the vetting process, given what almost just happened. So it's now gone through that process, and the encouragement is that people regularly interact in, whether it's affection or intimate situations, it's consensual. So there's no reason why that shouldn't extend to digital contacts. At some point, there needs to be, if someone's going to continue to do that, there needs to be some remedy in the law for a person the recipient of that. So I'll be supporting the motion about to pass, and I was happy to co-sponsor this legislation. See no further hands raised, the matter will now be put to question. If you support the motion of ought to pass, please say yea. If you are opposed, please say nay. The clerk will now call the roll.
Vice Chairman Roy.
Yes.
Representative Welch.
Yes.
Representative Burt. Representative Rhodes.
Yes.
Representative Green.
Yes.
Clerk votes yes. Representative Testament, not voting. Representative Lang.
Yes.
Representative Pratt.
Yes.
Representative Marston.
Yes.
Representative Harriet Gathright. Representative Schultz.
Yes.
Representative Rung.
Yes.
Representative Bourdonnais.
Yes.
Representative Perez.
Yes.
Representative Newman.
Yes.
Representative Bolden.
Yes.
Representative Conley.
Yes.
Representative Klein Knight.
Yes.
Representative Bradley. Chairman Abbas.
Chair votes yes.
20 yeas, 0 nays, 1 not voting. The bill passes. Certainly.
Representative Gathright moves for consent.
No objection.
Representative Conley, you'll be preparing a majority report. At this time, we will now close the executive session on House Bill 1388. At this time, we are now going to adjourn the Criminal Justice Public Safety Committee.